Kia ora tātou, nau mai hara mai ki tēnei hui mo te wai me te whenua tukumuti ki tēnei rā, nei rā no te mihi kia koutou. Welcome to the Water and Land Committee. I'll hand over to Councillor Burns to open with a karakia.
Kia ora, Mr. Chair. Tukua te wairua kia rere ki ngā taumata, pai arahi i a tātou mahi, me te tātou whai i ngā tikanga a rātou mā, kia mau, kia ita, kia kore ai i ngaro, kia pupuri, kia whakamoa, kia tina, hui ei, tākia.
Tēnā koe, Councillor Burns, e whakatūwhera ta hui i tēnei rā. Anei anō te mihi kia koutou ko rau ko mai i tēnei rā mo tēnei hui. E pai aki ki te ia koutou, ki ngā manuhiri ko tai mai kia kōrua. Pira rawa ko pō, nei te mihi kia kōrua, hara mai i tēnei rā mo tēnei hui. Pai ki te ia kōrua. A koutou, kai kaunihera, tēnā koutou hurinoa te whare nei, tēnā tātou katoa. Welcome everyone to the Water and Land Committee. Good to see that we have two guests here today to talk to us about some issues regarding the Rakaia River and also fish screens. But without further ado, I'd like to acknowledge everyone to be here today, and those ones who are online. Councillor Ward, and then we have Councillor Swiggs in presence now, so kia ora, Councillor Swiggs. Nā reira, tēnā koutou, tēnā tātou katoa. Just to confirm that the order of today has changed, and the in front of you is the order. So it'll be the order of papers will be 8.1, 8.6, 8.2, 8.4, 8.5, and 8.3. Just so we can bring the Rakaia Water Conservation Order paper up, so our guests can actually hear the paper, don't have to sit around all day to listen to that discussion. Other than that, we also have apologies from Chair Scott, Councillor David East and Councillor Edge, who are on council business, and as I said, we have Councillor Ward who is online. Are there any conflicts of interest items on today's agenda? Oh, that's right, of course, Councillor Sanko as well. Any conflict of interest? No? What? Oh, thanks. He hasn't put his apologies in, so bad luck. Apologies for Councillor Korako as well. That's a discretion from the chair. There's no public forum deputations, but we do, there's no public forums. We have our deputations. We will have two today. First, we'll call up Peter Trolove. Come to the table, please, Peter. Representing the New Zealand Federation of Freshwater Anglers is here today to talk about the Environment Canterbury media release on the withdrawal of the Rakaia Water Conservation Order Declaration. Kia ora, Peter. Get that 9 minutes, and then we'll have questions for clarification from the answer. So, Peter, over to you.
Good. I'll read this out because it's really detailed. Good morning. My name is Dr. Peter Trolove. I'm a Canterbury ratepayer and an executive of the New Zealand Federation of Freshwater Anglers. I would like to raise with the Land and Water Committee my concern that ECAN appears to be misrepresenting the facts regarding the on-off application to the Environment Court in recent media releases and all public statements by staff. I am specifically referring to ECAN media release November 13 in the form of email. Environment Canterbury resolves questions over its role in the Rakaia Conservation Law. Secondly, a post on the ECAN website 16 November 23 correcting the record on the Rakaia. And thirdly, a newsroom query regarding comments made by the CEO. With permission of the chair, I'd like to table my notes. Right, so the first one, the media release November 13, quoting from the media release, Environment Canterbury withdrawn its request for the Environment Court to clarify its role and RMA functions in upholding the 1988 Rakaia Conservation Order. In February this year, ECAN applied to the Environment Court for declarations that would clarify what the Council's role is in enforcing the water conservation legislation intended to protect the outstanding natural features of the Rakaia River. Council took the position that its role was to issue consents and monitor compliance with consent conditions in a way that was consistent with the Water Conservation Order. But this did not extend to a duty to enforce the observance of the water conservation itself. Chief Executive said the declaration was withdrawn on Friday as there was no longer any disagreement with the Council with the powers and functions and duties under NMA. We're glad to resolve the questions about our responsibilities as regulator. Released November 16, quoting, last Friday we withdrew our application to Environment Court to clarify our role in upholding the conservation order. The original declaration was filed in February this year, put forward 3 statements that outlined our understanding of the extent of its role in enforcing the provisions of the Water Conservation Order, and a statement on our understanding of how the Water Conservation Order relates to water storage in Lake Coleridge. The Science Director said that all parties involved in court proceedings came to an agreement that the statements put to the court were correct, and there was no longer anything for the court to decide. Given the agreement, it would be a waste of time and ratepayer money to continue the matter in the court, so we made the decision to withdraw the application. The court facilitated the process, has confirmed our role, and there's no benefit in continuing with the declaration, so we think the withdrawal should come as no surprise to the parties involved. Our role is to monitor consents and ensure consent conditions are complied with. The newsworm query from the staff member: we withdrew our application because we were satisfied that the questions we asked about our role were being clarified. It continues. Of note, we believe there has been a misunderstanding that requires clarification. While the EDS and Fishing Game New Zealand together and the New Zealand Federation of Freshwater Anglers made separate applications or own declarations, they used Environment Canterbury's case number and name on the cover sheet. This means the court combined these applications with our own. We were not aware of this. Now, the Federation's lawyer said this is incorrect. When we withdrew our application, new sentence. When we withdrew our application, the other application was drawn as well, on instruction from the court. My response: the Federation has been involved in this declaration as an interested party, section 274. As such, we have access to Environment Court regarding ECAN's declarations, received various court documents and records that are available to the public. Confidential discussions were managed by the lawyers. I've recently asked the Fishing Game CEO to explain the path EDS and Fishing Game elected to take in the court. I'm concerned about a number of inconsistencies between the court documents and feedback from Fishing Game with the various statements and media releases made by ECAN. I believe it would be helpful for those councillors present at this meeting to be advised of these inconsistencies and or lack of clarity in press releases made by the CEO and Director of Science on behalf of councillors and staff. So these are the facts as best as I can determine. Firstly, ECAN withdrew its application before the Environment Court had had the opportunity to give a decision on the application sought. Secondly, there has been no clarification on whether or not ECAN has a duty to enforce the observance of the Water Conservation Order itself. Third, whatever clarity ECAN achieved from this costly exercise did not come from the court. It still has not been determined who gives effect to water conservation orders. Both ECAN and the Minister for the Environment are saying it's not me. The withdrawal of ECAN from the Environment Court 10th November took EDS and Fishing Game by surprise, as is recorded in the memorandum of the Council for EDS and North Canterbury Fishing Game concerning withdrawal proceedings 16th November. This memorandum gave notice of EDS and Fishing Game's opposition to the withdrawal proceeding, highlighting unresolved matters and requesting a judicial conference to discuss those matters and confirm a way forward. Paras 13.8 cover the progress towards one set of declaration questions. A set of refined proposed declaration questions and a proposed set of relevant background agreed statements was circulated among parties on 25 October 23, with the intention this would be finalised in time to report to the court on the 10th of November 2023. However, I'll quote from paragraph 18. However, the Council advised EDS and Fishing Game on Thursday the 9th of November that it intended to withdraw the Council application and did this the next day. In response, Fish and Game and EDS requested a judicial conference after conferring with counsel for the council in an attempt to find a way forward. The subsequent record of the telephone conference, 21 November, gave a pretty succinct summing up of the court's position, paragraph 8. Obviously, as the regional council has now withdrawn its application, the court's decision-making powers in determining that application cannot be invoked. So my understanding of English is that means you cannot cite the Environment Court as the authority because they have not made a decision. So to sum up, the clarification that ECAN claims to have gained was not determined by the Environment Court. There was no agreement achieved in the Environment Court between ECAN and the co-respondents EDS and Fish and Game, although there was some refinement on matters that should be determined in their confidential discussions. 3, the court documents make it extremely difficult to accept the CEO's claim that ECAN was not aware of the court's attempt to combine the declarations, and that's been confirmed by the Federation's lawyer. As both the EDS and Fish and Game have decided to file fresh applications in the Environment Court, and the New Zealand Federation of Freshwater Anglers and New Zealand Salmon Angler Association are still to consider whether to reapply under Section 274 to the interested parties. Comments about not wanting to waste time and taxpayer money appear somewhat premature. The New Zealand Federation of Freshwater Anglers has found this whole affair to be most unsatisfactory in terms of time and money spent for no return. Since the Rakaia River water budget report was released, ECAN has spent 2 years getting nowhere in its attempt to clarify water storage and irrigation takes other than to propose a superficial conceptual model using a mix of real and estimated water use data. Manawa Energy's water storage and use remains unresolved. The New Zealand Federation of Freshwater Anglers has watched the ongoing degradation of the Rakaia River catchment and does not accept Environment Canterbury has truly given regard or effect towards preserving the values the Rakaia River National Water Conservation Order 1988 seeks to preserve. ECAN has not given effect to the Water Conservation Order itself. And I haven't written it down, but there's a footnote. The Federation of Freshwater Anglers is a not-for-profit incorporated society relying on I see. So we live pretty hand to mouth on donations from angling clubs around New Zealand, and it's pretty bloody disappointing for us to blow $18,000. I think that ECAN's got bigger pockets and could afford these charades, but we're pretty unhappy. Thank you.
Kia ora, Peter. Tēnā koe. Thank you for coming in today and sharing these issues and matters that you've raised today, and probably some of those questions you've put back to us. They'll be referred to the Chief Executive. But in the meantime, if there's any questions of clarification, I'll open it up to councillors. Any councillors? Councillor Burns.
Kia ora, thank you, Peter. Thanks for coming in. So I just have a point I just want to clarify is where it was reported that there was agreement between the parties, you're saying there wasn't.
Sorry, no, I'm saying.
Very good.
Sorry. If I'm getting your question right, I'm not saying there's agreement. I'm saying there's no agreement.
I'll just clarify what I say. So we are saying there was agreement. You are saying there was none. Thank you.
There was a confidential sort of trying to organise what to take to the court, where things were agreed to be put aside or brought forward or done whatever, but there was no agreement on the guts of the issues.
I'm just going to help with the button, so you can focus on your conversation. Sorry.
Yeah, what would you like to see the role for Environment Canterbury or some other organisation? Like, your concern of anglers is that the river and the values that it meant it got a water conservation order in the first place are degrading. So what do you think an organisation and you know, who else would it be if not ECAN? What would you like to see done?
All right, I'll help you.
It's fundamental. I think it's EDS's argument that it's fundamental to know who is accountable for giving effect to the conservation order. I think it's the primary thing to be resolved, and it hasn't been resolved. Secondly, it's a very good question that in New Zealand we get parliamentary commission for the environment report saying water quality is turning shit year on year on year, and it seems since Fish and Game has become part of DOC under the Conservation Act, the intensity that the Acclimatisation Society has used as sort of independent people has gone. Our society is far too small and we've got no money to fill that gap. But as an angler on the Rakaia River, from Lake Huron to the coast, yeah, I know this river well. I've fished it for bloody near 65 years. And so we're getting eutrophication in the lakes. We're getting the 40% of the river basically captured, ploughed up and ripped up in the Wilberforce Harbour Evoker. We're getting the fairway sprayed, massive swathes with defoliage. Yes, there's a river management reason for it, because by taking the water out of the river, we're getting aggradation. I understand that. But the chemicals, herbicides used are ecotoxic and wiping out the soil ecology and the feed that our recreational fish, the young salmon, require to get to the sea. So we're losing our salmon fishery. We've lost a species of native fish, which is fundamental to the ecology of the river mouth. We're watching the margins of agriculture encroachment, and we're watching consents given to farmers to do their own river works, which are damaging the river, and which I've reported a number of times rather unsatisfactory. So what the hell's going on? Because it's almost as if there's a conspiracy to stuff up the river from a fisherman's perspective.
Kia ora, Peter, thank you for that. Councillor Robinson.
Thank you very much for coming in today and talking. I just wanted just a wee bit of clarity on earlier in your talk, you discussed that the freshwater anglers had their documentation put forward with ECAN's logo or something on it. Is that correct? Or
I think it was, yeah, this is what lawyers do, I'm sure, but I think we were told to put our application against this thing next to the ECAN's application for the negative declaration ECAN sought. So that's how that came about.
So that's sometimes how they pass all things up for courts. Yeah. Okay. So that's just clarifying that. And also you mentioned that EDS did not agree to the withdrawal from ECAN in the proceedings, or?
Yes. Yeah.
All right. Okay, help you.
We had an exchange of email last week in which Gary Taylor of EDS and Rasmus were in the email link. I don't feel I can tell you the content of those emails, but I can say this took place and that was clearly the message.
Kia ora tātou, nei te mea te kia koe, Peter. Thank you for coming in. As I said before, the issues and matters you raised will go to the Chief Executive, and then you will receive a reply from the Chief Executive. But on that, we put the motions up. Who would like to move this motion? Councillor Robinson, seconded by Councillor Southworth. The receives a deputation from Peter Trolove from the New Zealand Federation of Freshwater Angler regarding agenda item 8.6 of the Rakaia Water Conservation Order update. All those in favour, please say aye. Aye. Kia ora. Carried. Thank you. Thank you, Peter. Kia ora. I'd like to call Paul Hodgson up, please. Kia ora. Paul's here today to talk about fish screens and the Rakaia Water Conservation Order. Once again, Paul, you have 10 minutes. You've heard the bell. So that'll bring it 9 minutes, and you have a minute to sum up, and then there'll be questions of clarification. So over to you, Paul.
I'm surprised and disappointed by the lack of communication. I believe there is still issues outstanding for determination by the courts. I also think it would be appropriate for MFE to exercise its powers under Section 24A of the RMA Act to investigate whether ECAN has been exercising performing its functions, duties and powers in respect of the Act, in respect of the 2012 amended Rakaia Water Conservation Order. New Zealand salmon anglers have also raised issues that require working group meetings over the years in good faith, and they insist that all questions are answered. A few of the questions not yet answered are detailed. Why is the Rakaia River in a degraded state today when it has the 2012 amended Rakaia Water Conservation Order on it? Where has all the water gone at the bottom of the river? Why has ECAN stopped having the Rakaia working group meetings for the last couple of years, even after New Zealand salmon anglers have asked for them to continue? And in conjunction with what Peter said, I think there's a bit of disagreement about whether we agree with ECAN withdrawing and didn't actually know that they were withdrawing, to be honest. Fish screens. Fish screen compliance is a good example why ECAN should not just be focusing on compliance with consent conditions, but need to ensure that the consent conditions are fit for purpose. A good example of that is CPW fish barrier, which is yet to be proved compliant with consent conditions since the design was signed off by Ryder Consulting in 2013. That's over 10 years ago. We consider, and their comment was, we consider that the design specifications of the fish screen barrier generally satisfy conditions 6 to 11 of the water permit, blah, blah, will be adequate to achieve performance objectives. There has been no request for it to be replaced by ECAN, as ECAN did for the RDRML's Bath fish barrier on the Rangitata River. How long do you need to prove, does it take to prove compliance? Why are anglers so annoyed about the whole thing? Well, to offset all fish being lost down irrigation raceways, Fish and Game have introduced a reduction in angler catch rates for salmon by 30%. This has taken the form of a 2-bag season limit to try and increase the number of fish in the spawning grounds. It is disappointing to see that CPW, DOC, North Canterbury Fish and Game and ECAN are yet to come up with a verification monitoring plan for CPW's fish barrier to meet 2 bottom line criteria for any effective, efficient fish barriers. The verification plans need to prove effectiveness and efficiency for a range of flows at each abstraction point where the consent operates. Mixed veggies are off the table as a verification test methodology as far as anglers are concerned, but it keeps coming up. The monitoring plan needs to be able to prove that there is connectivity for safe fish passage from the point of diversion to the screen area, from the screen area to the bypass, from the bypass back to the river. It doesn't matter if the fish is lost, can't get out of the extraction from the extraction point, so it gets back to the river. Lost to the river is lost to the river. And I suspect the same thing is happening for the native fish as well. The monitoring plan also needs to be able to prove that any fish removed from the river is promptly returned back to the river unharmed. Poor connectivity issues associated with novel fish barrier designs such as infiltration galleries and rock bunds can be seen in the reports for them for the last 15 years. The cumulative loss of fish to the river is best assessed on the number of fish released. This cumulative whole of take assessment of fish barrier results in efficiency ratings dramatically dropping from 90 to 98% recorded in the reports to about 20 to 50% when release numbers are used to calculate efficiencies. Well, the facts are the facts, aren't they? Again, the loss of smolt to the river shows a corresponding reduction in reducing salmon numbers for the last 20 years, hence the need to impose a 2-bag season limit on anglers. The calibration of fish traps is an integral part of the verification process for fish barriers. The gold standard was set by CSI Fish and Game when they calibrated the Bath bypass traps. CSI established the principle that trap calibration was based on releasing about 1,000 tagged hatchery fish at the top of the fish bypass, trapping about 10% of the water, and then recovering about 10% of the fish in the trap. When anglers settled their Rangitata appeal, this testing principle was our bottom line criteria for the angler settlement. The testing principle is also agreed by RDRML and ECAN and detailed in the finalised fish screen verification monitoring plan. The plan was signed off by all parties in good faith. RDRML advised there could be no changes to the plan. Anglers are yet to see any fish barrier that meets all of the above testing and verification requirements to prove that any of the holder take fish barriers are both effective and efficient, which is disappointing. The cumulative loss of these smolt across all the effective barriers in Canterbury, believed to be about 1,000 of them, is one of the reasons for the decline in both the salmon and the Canterbury East Coast trout numbers since 2000. Thank you.
Kia ora, Paul. Do you want to table your documents? Oh, sorry.
There we go. Yes, I will table the documents, and I will leave a shortened version, the first 30 pages of a 175 page document for the fish screen verification management plan on the RDR rotary screen.
Kia ora, Paul. Thank you for that. So thank you for coming in today. And some, as I mentioned before, the matters you have raised today, we referred to the Chief Executive, and you get a response from that. But any points of clarification, Councillor Pauling?
Kia ora, Paul. Just really interested listening in, trying to get my head around it all. I understand it's a really technical space in terms of the fish screens. My question is, you've mentioned the RDR one and the CPW one, and I didn't pick up that either of them are to your satisfaction or your group satisfaction. Have you seen a design or a working example that is good?
So this is the problem. Here we are, we're sitting around talking about a thing, and it's been happening in earnest since for the last over 20 years. The angular belief is that the rotary fish screen that was put in at RDRML will be very effective. But the evidence is yet to be collected. So the reason I make that caveat is because it's how the whole design is installed. So the key point is, and it's up to the irrigator or whoever it is to prove that any fish that are removed from the river, so at the point of diversion, has to be returned back to the river. So if you design your fish barrier, which encompasses the whole entity, then it needs to consider, well, if I make the intake 1, 2, 5 kilometres away, I'm going to reduce the chances of it even getting to the screen. And gosh, if I slow down the flow, as in for the rock buns and the infiltration galleries, I'm going to make it very, very difficult for the fish to find the exit point. And even if the fish find the exit point, as in the bypass, and that bypass is 5 kilometres long, and the chances are it's not going to have the water to get the fish back to the river. Now, the intake, infiltration gallery intake at Tiparita is a great example of that. The scientists did one test in which only 20% of the released fish actually found the bypass. But because they assessed it on only the recovered fish, not the released fish, I think it had a 98 or 99% efficiency rating. But the whole point, and it's all tied up in the water conservation law as well, you need to be focused on environmental outcomes. Doesn't, from an angling perspective, it doesn't matter a damn whether it's compliant with the consent conditions. Are the consent conditions fit for purpose? It's a bit like, well, if I put a plan, build a house, and the local council signed off that plan based on the plan and didn't have any inspections, I guess all the builders in New Zealand and all the construction companies will go, whoopee, it's all good. But there's no follow-up. And I believe under all consent conditions to do with water anyway, have a clause that's inserted something along the lines that ECAN can review that consent condition if there are any adverse effects. But how do you know if there's any adverse effects if ECAN aren't monitoring? And if ECAN are monitoring, can ECAN let anglers know what they're monitoring in terms for adverse effects? Because for me, the whole issue of fish screens and the Rakaia Water Conservation Order Declaration was to sort this out. Because for me, personally, the special character and the values and the health of Rakaia River is deteriorated significantly.
Oh, sorry, Paul. Thanks for that, Paul. So the adverse effects and compliance and stuff, we'll take that on board, and that'll go to Stephanie. Any other points of clarification? Sorry, Peter. No, it's only for us, mate. Sorry. On that note, Paul, thank you. Thank you for coming in, finding time for yourself and Peter coming in today. Not only talking about the Rakaia Water Conservation Order, but also the fish screens. As you know, we have the paper 8.2 and 8.6 on today's agenda. So you're welcome to sit in the council meeting and listen to those discussions. So once again, Paul, tēnā koe, and we've got the resolution on screen there. Mover, Councillor Burns, seconder, Councillor Robinson. All those in favour, please say aye. Aye, carried. Kia ora. Thank you for that. We'll move on. Move on the agenda. Catherine's just going to grab your papers on that or something. Yeah. There's no extraordinary and urgent business. 6, there's no notice of motion. Therefore, moving on to item number 7, the minutes. Are there any matters of action relating to the minutes of the meeting held on the 18th of October, which was chaired by Councillor Mackay? None. Therefore, just put the motion up. Can we have a mover? Councillor Mackay, kia ora. Seconder. Councillor Pauling. All those in favour, please say aye. Aye, kia ora. Carried. Moving on to 8.1, we have the Water and Land Committee Resolution Status Report. I'd like to call Tim for the table, please. Kia ora, Tim.
Kia ora, Chair. So reporting on the resolution status, and as you will have seen, the majority are green, and I'll leave those as they are and just report on the 2 items that are marked there as orange as ongoing. The first on page 22 of the agenda, concerning the nitrate testing of drinking water. The first part of that you'll see is complete, and that the campaign is complete. That's led to an update of information on the Environment Canterbury website, and then also putting that through to other agencies so that they're aware of that. And so that part is complete. The second part, which was the invitation, so that staff invited the Mana Ora territorial authorities and zone committees to work with Environment Canterbury in an investigation into running private well testing events. The territorial authorities and Te Mana Ora declined, but requested to be kept informed of any events that others may be planning. The zone committees are being asked to consider whether they wish to run a private well testing event as part of their schedule of activity for this current year. Should any of them wish to, staff will support the zone committees with these events, inform Te Mana Ora and the relevant territorial authorities to gauge their interest in also being involved. So in terms of that item that was there and requesting that we consider that to be complete. The second item there that's marked as orange is the Fish Screen Working Group, and there is the paper here today, item 8.2, page 24 of the agenda, which is addressing that issue. So I'll leave it. Yeah, thank you, Chair.
Kia ora, Tim. Are there any questions of clarification, Councillor Southworth?
Yeah, thanks, Tim. In terms of the private well testing events, I know that Selwyn Waihora Zone Committee, I believe we've just approved funding to run 2 or 3 of those. I'm wondering, are any other zone committees, that mightn't be a question for the other councillors around the table, are any other of the zone committees also going ahead with events? Because we found them very successful in the well attended when we ran them before in our zone, and we're doing some more.
Through you, Chair, what I'm aware of is that the Southern Zone Committee, so the 2 Waitaki Zone Committees, and OTOP have said that they are not. OTOP ran one last year and they're not planning another one this year. The Lower Waitaki have said that it may be a possibility, and we haven't heard anything else. So, if any, as you asked the councillors.
Right, Councillor Mackenzie.
Yeah, thank you, Mr. Chair. Tim, when I saw there was a press release around the pollution in Littleton Harbour, and the headline was fecal was something about the fecal contamination was from mammalian sources. And when you read the article, you discovered that the mammals in question were humans. I just wondered why we're trying to soft soap which should have been the headline, is actually the fecal contamination in Littleton Harbour was from human species in the first place.
I'm happy to answer that, although I don't believe it's particularly relevant to this item. But I would just quickly answer that I can say that we don't write the headlines, and we don't know what gets picked up out of things that we say. I do recall the interview, and I can remember saying mammalian and then struggling in my mind to think through what I was actually trying to say, and I ended up then saying that it was human, and that was kind of the pressure of an interview that obviously got taken through into a headline. It is true that the fecal source tracking in the harbour did show human source.
And if I may help you, the relevance is in point 2, where you talk about you talk 2.2, where you're identifying the sources of fecal pollution and informing the community as to the dangers of those things. So.
Councillor Mackenzie, finished there. Councillor Mackay.
Just going back to the question that Councillor Southwest asked, the Waimakariri Water Zone Committee has funded a piece of work out of their action plan funding, but it was around another focus, but we added in, it was around water quality in Waimakariri, but we added in the requirement to allocate a small amount of funding for running some ore testing samples, but wider. So we will be possibly looking at an education type campaign and making sure that we've got people in the room to provide information to those who have elevated levels, and it will cover, for example, pathogens and other things. So
sorry, that's precisely the same as we're doing so in Waihora. So the instantaneous test is on like freebie you get when you come, but of course the information about pathogens and the other aspects will be very much front and centre of that as well. Thanks.
Quite good to see the proactive Whakamutunga and so on those issues. Thank you, Tim. If there's no, one more point of clarification.
Yeah, just on that same piece, 8.2 drinking water nitrate testing. Is there any role for the Greenpeace Know Your Nitrate map as far as advising the community or linking them?
All information is welcome.
Any other points of clarification for Dr. Tim Davey? Cole? Thank you, Tim. Firstly, I'll put the motion forward, and then there's opportunity for discussion. The recommendations on page 17. The agenda, please. Therefore, reads notes the status of previous resolutions provided in the Water and Land Committee Resolution Status Report, November 2023. Please have a mover. Councillor Mackay, seconder. Councillor Southworth. Open for discussion. Is there any discussion? Cole? All those in favour, please say aye. Aye. Against? Carried. Kia ora. So moving to 8.6. Shuffle if you're on paper. Scroll if you're on the screen. 8.6 is the water, the required water conservation order. Tim, floor is yours. Lots of you.
Kia ora, Chair, and just noting also the deputations on this and the points that were raised that can't be covered in what's in this paper, but I will. There are a couple of things that hopefully provide some clarification around that as well. We've put this paper into the agenda because we wanted to put into the public the record of what has happened. The declaration was sought around the Rakaia Water Conservation Order, and we were the applicants. And there were 3 respondents. There were named respondents being Manawa Energy, North Canterbury Fish and Game, and the Environmental Defence Society. And then in addition to that, as outlined by Dr. Trolove earlier, a further 11 parties joined in the application, including the Freshwater Fishing, Freshwater Anglers Incorporated, sorry, the Federation of Freshwater Anglers Incorporated, and the Salmon Anglers Association that Paul is involved in. So they're the parties that were involved. And then broadly, there were 2 issues that were being sought. One was around the clarification of the statutory duties of the Regional Council and enforcing the Water Conservation Order. And then secondly, clarification of how water is stored and classified as stored water. And that was part of the Conservation Order change that came in, I won't get my years wrong, but I think it was 2012. I think I've got the right year there. But these things are never simple. And as the applicant, we being Environment Canterbury, put forward our view around what our duties were in terms of the Water Conservation Order. There were some further questions that were put forward, and this was alluded to this morning by the other parties. And I'll come back to that in a minute and to explain that. As part of the declaration proceedings, there was conferencing, and as part of that conferencing, I wasn't party to it. I can't talk in detail around that, and it's also part of Environment Court proceedings, so it's a little bit tricky. But when we put forward the declaration, we put forward 3 statements, and I'm reading from the paper here on paragraph 6, that outline the council's understanding of the extent of its role in enforcing the provisions, and then 1 statement about the water storage issue. There was conferencing that was entered into by all of the parties. That was at the request of the judge. And at that conferencing, there was information presented, particularly with regard to the management of Lake Coleridge and the Rakaia River. So that was to do with the water storage issue. In the conferencing, all of the parties came to the understanding that the statement regarding Environment Council Canterbury's role in enforcing the Water Conservation Order were correct. And then the summary is outlined there about compliance, consents and compliance. In addition, the parties agreed that they no longer wish to pursue a declaration regarding stored water. So that was to do with the acceptance of the information that was put forward. Following that conferencing, Environment Canterbury made the decision to withdraw from the application. In terms of the other question, that's the position, and in the paper you can see I've also attached the Environment Court information or the application to withdraw. Since this paper came out, because it has to go out 7 days in advance or well in advance, there is a further record of a teleconference that has been released by the Environment Court. So this was a teleconference, and this was referred to earlier this morning, a teleconference on the 21st of November, which is a summary of the conferencing that had gone on and was sought by EDS, the Environmental Defence Society, and Fish and Game in response to the withdrawal, where, as was correctly stated, they were objecting to the withdrawal. So so there was a teleconference on the 21st of November, and that is summarised from the Environment Court. In essence, the court supported the withdrawal, but it also acknowledged that there were further questions that were sought from the other parties. In paragraph 9, and I haven't got it here, I can circulate it later, but in paragraph 9, it outlines that these were filed incorrectly, and that's a filing issue to do with the court, and therefore couldn't be considered, and a new application will be required. Now, if you think about it, I'll put it another way. Environment Canterbury was the applicant and they're the respondents. Environment Canterbury was satisfied that in putting forward its case, there had been acceptance by the parties on what the role of Environment Canterbury was and to do with stored water. The further questions essentially flips that applicant respondent around, so that the respondents, so Environmental Defence Society, Fish and Game and Manawa Energy, would become the applicant and we would be the respondent. The court doesn't have that ability to be able to flip that around. Then there was this issue to do with the way that they were filed, and that's a court matter. What it means is that for those to be considered, the Environment Court determined that it requires a further application. Now, we have been in discussions with, I've personally spoken to Environmental Defence Society President, Gary Taylor, and also to the Chief Executive of Fish and Game. Around this, we are expecting that they will put in an application around those further questions. And the further questions are generally around, if that's Environment Canterbury's role, whose role is it in the wider water conservation order? Is it the Minister for the Environment? Is it a regional council? And I should stress here that this is the Rakaia as a case study for all water conservation orders. It's not just about the Rakaia. It's for all conservation orders. And the statements that are being made around the use of public funds is really partly to do with that, of this is much wider than just the Rakaia. How should that be funded? So in terms of the spoken to EDS and Fish and Game, they are intending to file. I was talking to Fish and Game yesterday, and at that stage they hadn't filed, and we're expecting at some stage EDS indicated that it might be this week, but we just have to wait and see what happens there. We need to look at those questions, and then we are expecting to join. We know that we will be named as a respondent, and we then just have to look at those and consider how we are wanting to carry on. This is to do with who's the lead and who's the secondary. And as it turns out, under the Environment Court procedures, that required flipping around. It couldn't be done. The good thing is, from an EDS and a Fish and Game perspective, the court has indicated that they haven't lost their place in the queue, that they're not kind of forced back down to the bottom, that because of this filing issue, that they still hold their place in the queue, and we're expecting that to proceed. So that's probably as much as I can say, and I'll leave it at that. Thank you.
Kia ora, Robin. Anything you'd like to add? Oh, kia ora. Any questions or clarification? Mackenzie, Robinson, Worley.
Thanks, Jan. Tim, can you just, sorry, when you said the further question that's been asked by what were the respondents who now become the applicants, you said it was regarding the water conservation order, but the court, the conference has already determined ECAN's role in terms of affecting the WCO. So what is this? What are the specifics around this further question? I'm not sure I quite understand what exactly what the question is that they're asking.
Yeah, and I understand your question, and of course we need to see the absolute question, but we have a pretty good idea on, because there already has been questioning around that. First of all, and it is an important point, and it was made earlier this morning, the Environment Court hasn't determined this. It has been agreed at conferencing around the Environment Canterbury position. So that's not quite the same thing, and accept that point made earlier. The question is around, we put forward our role, which is to develop plans and to issue consents that line up with the Water Conservation Order and to check compliance against those consents. That's what we've said is our role. There is a further question around who is checking that the values outlined in the Conservation Order are being upheld. And I'll just give one example around that I think perhaps clarifies it to a certain extent. If we take the Rakaia, the Water Conservation Order is concerning three things: braided river status. So it talks about the, say iconic, but it talks about the braided river nature of the Rakaia. It talks about the salmon fishery and the outstanding nature of the salmon fishery. And it talks about jet boating. And yeah, so it talks about jet boating. So a good question is, whose role, we can set plans, and we do, that align with the Conservation Order, allow for enough water for these values. Is it Environment Canterbury's role to be monitoring jet boating, to be monitoring whether jet boaters are getting the correct experience? That's the sort of question that is being put forward around the wider values of the Conservation Order. That's an example. I'm just using that as one example of it. So those are the questions that are being sought around that wider question.
Clarification.
Yeah. Just to flesh out the question and answer here, if I may, Jan. I get your answer, but I wonder, isn't ECAN's role in setting the consent conditions so that those three, the reflection on those three values in the Conservation Order are adhered to? Is there any? There's no other way that a regulatory authority like ECAN can adhere to a Conservation Order, as it happens.
And that's the point that that's the position that we put forward. So that's what our position was.
As a jet boater, I can tell you the Rakaia is still quite good to boat.
Okay, it's enough from you. Councillor Robinson.
Thank you. Just a bit of clarification, probably directed to Robin. Because it wasn't really a determination of the courts, Robin, sorry, because it wasn't really a determination of the courts as such, is it still considered sub judice?
Sorry, can you repeat that question? Sorry, I was just...
Because it wasn't a determination of the courts as such, they just agreed to the withdrawal. Is the situation or the understanding is it's still sub judice, like still before the courts, or are we free to just comment on a couple of things freely? Thank you.
Our application is no longer before the courts, that's correct. But we do have to be mindful of keeping the confidentiality around conferencing and matters involving that, but you can speak freely on the documents that are out in the public.
Thank you for the clarity. My comments are just relation to section 17 of the RMA and our role anyway, for the state of the environment as a whole. I just don't want us to lose sight of, I guess, our duty of care, and acknowledging that perhaps even though it was adjusted, and I believe, was it 2010, the water conservation order, whether or not it's still fit for purpose, and whether or not the water conservation order actually, the storage of the water facility at Lake Coleridge is detrimental to the water conservation order. And I believe under the RMA, it's a multi-agency approach. However, we're still obligated, I believe, my interpretation of it is section 17 still applies. And
oh, sorry, Councillor Robbins, is that just clarification for the? All right.
So am I correct that we still need to maintain or monitor the effects on the overall health of that river, whether or not a water conservation order applies? Because we do have consent holders on the river, so we need to have some sort of duty of care. Is that correct?
Yes, it is correct. Just like any other river in Canterbury, there is the need to monitor the health of that river. Yes.
The supplementary being that, in your, I guess, in your view, do you think the water conservation order is still fit for purpose?
I don't believe I can answer that question.
Yeah, that's a tricky question, that one, Councillor Robinson. Councillor Pullman.
Just you mentioned that other further record released by the Environment Court. Can that be tabled at our meeting? Because it's obviously, to Councillor Mackenzie's questions, that might clarify some of that stuff. That would be helpful, I think. That's my first question.
Yes, that can. That's in public record, so that can certainly be. And I would have liked to. It just came too late for these papers.
Great. And thanks to our two public forum deputations this morning, and also to your explanation, Tim. I know in our papers there about engagement to number 15 and 16. I get what the words are saying there, but I really wanted to understand, what engagement did we, other than the conferencing, what engagement did we seek, or feedback did we seek from Runanga and other parties ahead of making our decision? It's not clear there.
You're referring to the decision to withdraw from the conservation water declaration. I'm not sure I can answer that, and I'm just looking to Robin to.
Our council did discuss the withdrawal with Runanga solicitor. There's a barrister and a solicitor acting for Runanga, and they were advised before we made this decision.
Cool, thank you. Like, I just think that's a point, like, we should just say that. But in our papers, like, I'm always going to ask what engagement we've done with our Brunanga when it's not clearly stated in that section that's specifically around that. So, yeah, it just would have been good to put that up front. Yeah, thanks. Yeah, that's one question.
Yeah, it's interesting to think. I'm really interested in the question about, we're hearing that there's been a degradation in the river in the smelt population, I believe, in this particular one. It's interesting to hear those 3 key points on the water conservation order being salmon, braids, and jet boating. Like, seems like there should be some other values in there, so maybe that water conservation order needs to be revisited. But ultimately, is there a less adversarial way? Like, how could we work with, in order to, we all recognise that there's a degradation of this river, just as we've been doing with Otu Wharakai, for example. Is there a more constructive way that we could look to understand how we improve the quality of this river back again towards why it got a water conservation order, plus the values that we've perhaps come to value more over the last 10 years or so? Because I can't believe that those 3 things are what we've got. I get braids, but the other bits, and no disrespect to salmon angling, but I see a healthy salmon as being something ultimately, the key species for me would be the native fish. But at least healthy water means healthy native fish as well. So, I sort of get that. But yeah, what could we be doing? I mean, the 2 questions we've had are answered through the courts, which I'm sure has cost a fair old wedge, but like blindingly obvious to me. Like, we're responsible that our plans align with the water conservation order. Well, no surprise. And our consents have to be compliant with our plans, and we have to monitor them and make sure, like, there is nothing that's come out of that a complete layperson couldn't have told us. And yet we spent, I don't know how much on that. But to me, it's the important thing is, how do we improve the quality of this river? So what do we need to do, and how can we do this in a less adversarial and costly way? Or is this the only way? Thank you.
I think there's a couple of things in there that I can answer. The first is, I said about the Rakaia being a case study around water conservation in general, and that's what I think the legal side of it is concerning around. The second side is about the Rakaia itself, and I'll come back to that. And just to add there, that the second matter of that was actually about the stored water and the way that that's described in the conservation order and the information that we hold that comes from other parties. So that was the second matter. It wasn't the first was about our duties. So I think that the question around the conservation order, well, and actually, sorry, one other point that you raised in there was about other values. That a water conservation order, because it is a piece of national legislation, it's not a regional, kind of regional, it has to have nationally outstanding values. And that's what, so that it doesn't say that the other values aren't important. It's just saying these are the outstanding values on that river in particular. So that's where a conservation order is a little bit different from other things. So it shouldn't be taken that the other things aren't important. In terms of the forget my place here, and apologies. Then there's the kind of the legal question, but the real question is what can we be doing? And look, I think there's a huge amount that we can, and I think that there has been, there's been frustration on all sides. Let's put it that way, and I understand that frustration around the sorts of things we can be doing. But I'll give an example again, which is in clarifying that stored water question. One of the things that is really shown to us, and we knew this and we've been working on it for a while, is we need to get the information out there on a daily basis, what is happening on the Rakaia. the flow is 150 at Fighting Hill. X amount has come in from Coleridge. X amount's going out to CPW. X amount comes in from High Bank, and there's these complicated flows. We've got that information together now. That's been part of the modelling work that's been going on. And what we're wanting to do, and we're working hard, is get that information so it's fully available for public to be able to see it. That's just an example of we need to do work around the Rakaia. And there certainly is the desire to look hard at the way we treat compliance, to look hard at the way we get our information out, and to look at some of these issues. And that's ongoing work, and we fully intend to continue doing that. And that's part of our continued engagement with other groups as well.
And question to that then is, if once we get this data and it's publicly available, I'm not even sure daily is necessarily sufficient, because I would imagine some of these things can flux quite rapidly, potentially in one day. But if it's shown that those flows now are clearly not actually sufficient to enable a healthy and thriving smelt population or whatever, what is the mechanism for us? That suggests that cumulatively the consents that we might have granted, or in good faith, in believing each individual one, it's this cumulative question all the time, isn't it? What's the mechanism? What mechanisms do we have to try and wind back and reinstate quality in the flows and so on? Like, what's our next steps once we've got that really clear?
Just in terms of the daily question, that's just a question of, you're talking about water takes, and we don't get that less than daily. So it's not quite, we can't do it. We can do the flows, but we can't do the takes, because we get that as daily information. So that's, but it's considerably more than we show at the moment, and it would be a huge. It's something that we're working towards. The mechanisms that are available. Look, I guess the way I would look at this is that the water conservation order is like the bare minimum. We have regional plans that we can, we can go beyond the water conservation order. So the water conservation order sets out how much water can be allocated out of that river. It sets out a flow sharing regime and a few things like that. We make sure we're compliant, that lines up with our plans. But we can go beyond that. We could put a flow regime on the Rakaia that took less water, and then we'd have to work out how we get that back from consents that are already issued. But so the mechanism is through the water and land plan, and that it can be amended. It requires the evidence around what's happening on the Rakaia and things like that. So it's no different from any other river, except that there's a kind of a minimum standard set through the conservation order, but we can go beyond that.
Kia ora, Tim. Councillor Smith.
Thanks, Chair. I don't, and it's actually just following on from Councillor Pauline's questions. The report itself, and I don't mean to be contrary in this, but I don't like this report. It just doesn't really tell me much from what I'm seeing, and kind of what Councillor Pauline was saying. I was looking at it from the risk point of view, not the engagement point of view, and I looked at point number 14, saying there are no risks associated with the decision sought. Yeah, there is no decision in this paper, but there's a lot of risk associated from the decision that you guys have made, especially now here, especially with the differences of opinions and all of that stuff. And we need to understand that. I need to understand that, because as soon as we go into risk stuff, I mean, some of the risks that I'm off the top of my head, there's precedent risk, risk of litigation, reputational risk, uncertainty is another risk. I want to know that, especially when we're going into long-term plans and budgets and those kind of things. We kind of have to have an ear to these type of things. So, I mean, I would have liked to see a lot more of that. But how can we get those things into these papers so that we're actually having better overseeing on these things? I don't know if that's a there's any way you can answer that question, but I'm just saying that, you know, I was a bit disappointed when I did read this paper.
Through you, Chair, I understand what you're saying. I'm just going to pass on to Robin.
I think it goes back to the instruction. So when the paper was asked to be brought to the Land and Water Committee, it wasn't on the it's not a decision that we're seeking for this committee to make. The decision's been made under delegations, and the authority is delegated to the chief executive. So we were under the instructions to prepare a paper that would note the decision and the reasons for the decision. So therefore, those procedural parts of the paper, in terms of the risk and the finance and engagement, they pertain to the decision that's being sought in the paper, and the decision here is to note. So we could have prepared a more fulsome paper and answered those questions if that was within the request.
Robin, and that comes on me because I requested this paper down as the chair, just because the articles I read in the press was just kind of, there's a lot of misconception. So I asked for a more on the engagement kind of side of the paper, just to show the process of where they got to, how they got there, and then I suppose the decision, you know, from our legal counsel. So in a sense of, I'll take it on board as the chair regarding the risk. I suppose that didn't cross my mind at the time. Yeah, and it kind of was more about engagement and kind of getting and then showing the public, actually, you know, being shown instead of just kind of being on press releases, actually front footing it public. So therefore, it opened it up for deputations as well. So thank you for your comment on risk, and I will take that on board next time we have a paper similar. And it was a short time frame, as Robin said. We only had a couple of days or 2 days to put that paper forward. So thank you for those points of clarification. Councillor McKenzie.
Actually, just in relation to point 11 on page 54, where it talks about the wise use of ratepayers' money. Do we have a quantum as to what it's cost us so far as an organisation, and if it goes forward and we're respondents, what it's likely to cost us in the future?
Through the chair, we could do some work on those numbers and report back, but I don't have that information to hand right now.
Last but not least, Councillor Burns.
Sure, thank you. Yeah, mine's very similar again, following on from Councillor Swiggs and Councillor Pauling. Given that there's extensive public interest in Rakaia, and certainly the work, can I just ask a question? Are you the Paul Hodgson was in the Seven Rivers Walking documentary some years ago?
Yeah.
Okay. Sure, thank you. Yeah, I recall seeing that documentary and the concerns back then. So again, given the extensive public interest, my two questions is one around process. Did we notify any of the respondents before we withdrew?
Through the chair, our council did notify, I believe there's 10 parties, and there was a process of going through. I think they reached 7. There might have been some messages left for some of the parties, but we can provide that information if you need the particulars.
Thank you. It's just by the sounds of some of the stuff that's been in the media, some feel that they were blindsided. And my other one goes back to the requirements, I guess, for councils to be a lot more transparent to our communities, both through committees, in committee, and I do understand, you know, there are sometimes limitations whenever there's some sort of legal action, but is there an opportunity to reduce some of the secrecy, if you like, behind the conferencing and outcomes?
Well, just that this process is a process that was run by the CEO, and it didn't involve council. I was aware of what was going on. She may be aware of on this, but the decisions on this stuff were Stephanie's. They weren't council decisions. As always, in terms of this stuff that has got some legality around it on behalf of the organisation, we get advised rather than asked.
Thank you. And I get that. And with the greatest respect, though, I'm beholden to 60,000 people in the central ward who expect me to be as open and transparent as possible, and also my role across the region. So, kia ora, thank you.
So just in response to that, this has been an ongoing process which was fairly well documented, and councillors were involved and made aware of the process all the way through this. Now, some of the councillors sitting at this table may not be aware of that because it was started in the last triennium. But as far as I'm concerned, then councillors should have known the process that we were in. The final decision in terms of where it ended up after the court decision was Stephanie's.
I just wanted to respond to that, if I may. I personally don't think it's wise to notify a council of a decision post a media release. And that is the position we're in here. I want that on the record. Is that in future, please, can we have transparency about the withdrawal or decision making to that effect? Thank you.
And we can bring that up in council any time as well, Councillor Robinson. So no more questions of clarification. What's that? Yeah, we'll note it in the notes. No more questions of clarification for you, Tim. So thank you for that. Therefore, I'd like to, and also Robin as well, thank you for your responses. Therefore, first I'd like to put the motion, and then there'll be an opportunity for discussion. And then note that it says notes, as because this was put forward by, because the decision had already been made, and it's forward by myself, that the Water and Land Committee notes the update as the Rakaia Conservation Order Declaration proceedings and the reasons for the Canterbury Regional Council withdrawal. I will move this because it was from me who put that forward. Seconder, please. Councillor Burns. I've already kind of mentioned my things. Is there any discussion from you, Councillor Burns? Open for discussion. Any discussion? Councillor McKenzie.
Well, just one point, and Vicky made the comment that we all know that the Rakaia River is degraded, and I think she was referring. She did refer to water quality, but she was also referring to the nature of the river itself. I think it's important that we clarify that I don't think there is any suggestion that water quality in the Rakaia River is degraded at all. In fact, all the testing shows that it's still pristine. And I think there's some question as to whether the quantity of water that goes down the Rakaia River has actually had any significant effect in terms of the quality of the river as a fishery. There is an issue with salmon fishery. There's no disputing that. But whether that's because of the nature of the river or other factors that are affecting the salmon fishery out to sea, and there is an issue with one variety of smelt in the Rakaia hapu, but in fact there's fishing samples have shown there's large numbers of others of the common smelt down there. So there are a whole lot of stuff that is going on, but whether that's actually a reflection on the degradation of the river, I think there's a slightly, I'm not sure that you can claim that we all know that the Rakaia River is degraded. You might think it is, and that's fine. I'm not disputing that. But I would argue that a lot of us think there's actually not much wrong with the river.
Kia ora, Councillor McKenzie and Councillor Southworth, would you like to respond?
Yeah, well, just to say, my comment about salmon and water quality was in respect to the fact that salmon is not a native species, and that the salmon fishery, in terms of my opinion, the benefit of salmon being considered as an ecologist or someone of an interest in the ecology, the reason why it's a good thing to think about the salmon is because they do at least you have to have a certain level of water quality in order for salmon to be healthy and functioning as a population in the water. The fact that there is degradation of the Rakaia, and I didn't state specifically water quality, but just in general, there is a degradation of that river. That river has, in aspects of its value, such as the fisheries, they have declined. That's an absolute fact. They have declined, and that there needs to be consideration as to how do we recover this river and its fisheries, all the different types, the salmon, the trout, the things that have been valued through the Water Conservation Order, but also the native species and so on. So just to be really clear about those two things. One thing I would like to say is it sounds like we acknowledged or we let people know literally the day before we pulled out on this the legal proceedings, and I do feel like it would be courtesy to give people a little bit more notice than just a day, so that they can actually genuinely give a response back, because it sort of sounded like, I mean, if I've understood right, you know, we gave very little notice that we were considering pulling out, and then we pulled out. So I don't know that we had much time to come back. And personally, as a councillor, yes, I would like to have known in advance. I know Arunanga have heard, and that's good in advance, and that's good to know. But as a councillor, it would be nice to have known as well. Thank you.
Got a councillor Southworth. Yes, I think points taken on that one. The councillor.
I'd just like to answer back.
No. Oh. Councillor Swiggs.
I'm actually just going to say that I'm going to vote against the paper. I don't feel comfortable voting for it just based on the things that I said before. There seems to be just some imbalanced perspectives and things that I don't think from the conversations that I've heard that aren't in the paper, so I might vote for it.
Councillor Paul.
John, as I said before, just acknowledging the deputations we've had this morning, and of course what we've heard from Tim as well. I think fundamentally it's really, it's sort of good to hear that further question is hopefully going to be put to the court about who checks or who leads, and like we heard from our deputations, who manages looking after the values that are put in the WCO. And I think, you know, from my experience being involved in the water conservation order at Whitewater and giving evidence in that hearing, of course there are things that are put as outstanding within those WCOs that, you know, regional councils don't necessarily have the lead on. For example, fisheries. And so, you know, you can see where things can fall through the gaps if there's no agency that is being responsible for them. I mean, they are listed on the MFE websites, of course. That's where they sit. I've just had a look at them. But, you know, who does assist with those other values that aren't necessarily a regional council's sole focus? So, you know, I'm looking forward to that. I hope, as Tim has outlined to us, that EDS and Fish and Game will put that further application. And it is, you know, it's interesting and you know, sad to hear that it wasn't filed correctly with the court, and or that the court made a mistake there. That's not great, but hopefully that gets rectified and there is a chance for this to be heard, because I think it is important. Like Tim has mentioned, this is not just about this Rakaia water conservation order, it's about water conservation orders generally. And it's important that we get that sorted out so that there is assistance for the community, for mana whenua, for councils that all have an interest in why these are even in place in the first place, and upholding those values they get decided has been outstanding. So yeah, I'm a bit like Dion, like it's a toughie, you know, like we're not really making a decision, we're just noting. But I'm happy to note it, but also, you know, have those things noted that we've raised, that, you know, more clarity while we're not being asked to make a decision here on this. You know, that fuller information in the paper would have been helpful, I believe. And I'm very keen that, you know, the record is tabled from the Environment Court to help us understand where the latest is at. And I understand that that couldn't have been done before the papers were out for this meeting, but yeah, just think it's really important. But yeah, just I'm going to be looking forward to seeing that question put to the court. And, you know, I'm assuming we will be joining in some way, and I would support that. Kia ora.
Kia ora, Councillor Pauline. Thank you for that. Yeah, similar to myself. I mean, this reason I put this paper on the agenda, just, you know, to show that some of the reasons why we drew from the court. Unfortunately, as you said, they weren't. There was a filing error and they weren't coupled, so therefore it's hard to. So they had to withdraw if EDS and also Fish and Game, etc., go back in. That we flipped. We became the applicant, we become the respondent. But the bigger question is the WCO regarding, you know, how's the MFE issues, you know, MPI built into this as well. Yes, we do consent, and we do have to look at compliance, and looking at some. I mean, Councillor Southwest did talk about how do we look at the Rakaia, and if it's the water and the QMEX, etc. Similar to what has been done on the Hakatere Ashburton, there could be a review of consent if it need be, but that's a process we need to follow. And as Dr. Tim Davies already mentioned, that there's that the WCO is the bare minimum. That's what the values got put on the river, but there's greater values than that, and that they're covered hopefully through consent and compliance. And also remember we have the integrated planning, hopefully, and the RPS. That's a lot of these issues regarding the Rakaia, and also the values brought by Taumatu and Tuahuriri on that river will be able to be come to the fore as well. So on that note, we have a mover. I moved it, and we also have a seconder, Councillor Burns. All those therefore putting into all those in favour, please say aye. Against? On that noted, yes. Against? Against. Okay, 2 against. Please note. Councillor Robinson. Therefore, it's carried. Kia ora. Right, midday. I mean, so we're going to move on to 8.2 for screens, and just notice we have online a few people. I can't see them. Sorry. Mike Hickford, Ross Millerchamp, and Stephen McNally. So just acknowledging you coming online for this paper 8.2 on the fish screens facilities program, conducting role of advisory group. On page 24, I'd like to ask Mel, Ringa Nathan, and also Judith, welcome to the table. Over to you.
Kia ora, councillors. Thank you very much for the opportunity to speak to you. So basically this report is in response to the request made by the August 30th meeting of the Water and Land Committee for a report assessing the opportunities and needs associated with a program of work relating to fish screen facilities. I'll just refer to them as screens from now on, including the role of an external advisory group. So as you're aware, fish screens are a requirement of our surface water takes to ensure basically that native and sports fish are kept out of intakes and or returned safely to the river. So this is basically to ensure that fish populations are protected. So over the years, many organizations, including ECAN, have supported improving our understanding of what's needed to make the screens more effective. The latest work was completed by the Fish Screen Working Group, and you would have heard from Fish Screen Working Group members in the August meeting about the results of that project. The Fish Screen Working Group included members from a number of organizations, and as part of the regular review of that Fish Screen Working Group, members and ECAN who convened the Fish Screen Working Group agreed that basically the past Fish Screen Group had served its purpose, and if there was a role for another advisory group, it needed to be more focused and more technical to provide the support needed for ECAN's program, which we're in the middle of planning. So the report in today's agenda provides an initial high-level assessment of a proposed ECAN work program, which covers key aspects associated with making the screens more efficient and effective. So we're proposing basically a program that covers policy settings. So basically making the RPS and integrated plan more tailored towards the new information on making fish screens more effective. And this work has already begun. Improvements to ongoing compliance monitoring and enforcement work, including completing the work to standardize templates and process, training staff, and following the work of the Fish Screen Working Group, which you heard about at the previous meeting, ensuring that industry providers are aware that consent holders will now be coming to them for information and product. Part of that program also included looking at investigating the role of an external advisory group. So a workshop is planned to be held early next year to discuss draft terms of reference and a draft program for that technical advisory group with some key technical experts. And some of the work that a technical expert advisory group that they could do was look at the review of the 07 NIWA guidelines and provide technical advice on the integrated plan. So of course, please note that the scale of this work will depend on where this work fits within Environment Canterbury's delivery of the Environmental Regulation and Protection Core Service, and staff continue to work on this. And also, if a technical working group is needed and has to be set up, it would actually need to support the ECAN work program. So it'd be working very closely with operational staff, and the TAG's progress, the technical advisory group's progress would be included in staff's regular reporting to councillors.
Kia ora, kōrua, thank you for that. Any questions of clarification, Councillor Swifts?
Hey, excuse me, thanks for the update and the report. When you were talking, you were saying there's a work program or something being proposed. I don't want to get caught up with too much of the terms, but in the recommendations, we're only noting something. So what is it that? So what's the mechanism of what you're proposing? Is it just happen, or I mean, I notice and also the financial implications that we'll need to consider it in the long-term plan. So I just wonder if are the recommendations fit for what you said and what I'm reading in the paper.
Sorry, I'll attempt to answer your question, Councillor Swiggs. I think we've taken a view of providing an initial assessment around our program of work relating to fish rats, because it's clearly in that new core service of environmental regulation protection. There's moving pieces in our conversation about that as we prepare to enter the long-term plan. So this was that initial piece of work. A lot of what we could deliver and to what will depend on some of that, the compliance uplift conversation, for example, within that long-term plan discussion. So we're identifying that's a piece of work we have a role and responsibility to deliver. We've built into the plan an uplift. If in the deliberations that changes, that level of uplift, then we would have to cut our cloth to suit. This is where we haven't gone to specifics here because staff feel that's most appropriately carried through the LTP conversations. In the meantime, how do we prepare engaging with those technical and people that have been involved that could offer that service in the future, and we could draw on about that level of involvement. So we kind of got a divided space here between a long-term plan but an engaging of the role they could play. But unlike the working group previously, that role would be with staff at an operational level, not coming to council.
Councillor McKay.
Thank you very much. Thanks for the paper. I have got quite a number of questions, but I'll just focus on one, and it's some recommendations that came back from the former working group around mechanism, perhaps that a technical advisory group could provide guidance and technical advice to consent holders. Do we, if it was to be our technical advisory group, or we would fund it, do we currently provide similar sorts of advisory groups out of the building? I'm not aware of us doing so. Or would we be setting up a precedent here where we would fund this group to provide the guidance and technical advice to our consent applicants?
This is some of the area we're navigating through as we look at this because of those sorts of questions. So I don't have I'm uncertain. I don't know if anyone online has the specifics of a yes or no. Is there a similar scenario? But that is part of the complexity at that operational level.
Burns.
Thanks, Mr. Chair. It's just in response to that question. Would something like the biosecurity, the technical biosecurity advisory group that would be something like a similar type of function here?
The difference would be the fact if it was advice on a consent aspect that then has that would be the difference versus one's not tied to a consenting function.
Councillor Southwood.
Yeah, it just it's obviously been a really long ongoing issue around fish screens. And I know under point 23 there was still that we're struggling to have capacity to follow up on 131 non-complying fish screens. And it's being actively worked on. But I think my feeling is it would be good to have some timeline, like this is discussing a work program, but it doesn't nail it. It's like responding to the report that came back to us from the working group that's been disestablished. And given that it is a really significant issue and it has been for a long time, could we make a recommendation for some more sort of more concrete report with some recommendations as to a work program or what's going to come through in the long-term plan, maybe for sort of like March or April time? I've just had a quick look. We don't have a calendar in our diaries yet for committee meetings next year. So I couldn't put a specific date, but it just feels somewhere between us making decisions on the long-term plan and you know, sort of those types of things, and after this workshop that's happening, to sort of go, actually, you know, where are staff at? What's the capacity issue? Is that still a thing, or do we need to, you know, some additional funding? What actually are we suggesting happen? What staff recommending, so that we're across it, because it does just seem like a significant issue that's gone on and on and on for years and years and years. So I think it would be good for council to sort of really be kept abreast of it, and not just to go into, you know, just be dealt with by staff and we don't get kept up to speed.
I guess I wanted to just mention two things, and one is probably a point of clarity, if that's okay. The intention after there was an intention which wasn't explicit in the paper around updating the outcome of that workshop by something like a CI, not necessarily a paper in this committee. Okay, so the two about it were informed. I'm hearing you requesting a paper, and of that having two components, and this is the bit I just wanted clarity on. One is about the outcome of the conversation about the opportunity of tag and probably a little bit more about what would that terms of reference be. That one.
The workshop, what I'm understanding is that we're looking at whether a technical advisory group, something that's formed, is necessary and beneficial. So there's a question mark over that. So that would be good to, and this workshop will presumably come to get a better understanding of that. But also then the what else, because clearly there's an issue, so we need to know, well, what else. And it would be good, I think, for public, because it's a public issue, you know, people want to know about this stuff. So I think that's why, for me, it needs to come back as a report to council in the public domain, not be something that just comes through a report just to us as councillors in private.
The second part of just clarifying was you've referred to, sorry, I think it's paragraphs 21 to 23 there around the which is more our compliance monitoring. Is that, just wanted to clarify, is that the other expectation in that paper?
Yeah, I can update on where that's at, because at the moment it's saying, yeah, we have these issues, we've got a number to them. We know we aren't able to address these maybe as fast as we would like, but I think let's see where we're at again in a few months' time, and what are we going to do about that through our long-term plan. I think that would be good to have some further information on if we can. And it's all tying it all together and bringing, like, you know, where are we at in another few months. So I'd take your advice as to where in the gap between now and long-term plan deliberation, so on, where would be a useful time that could actually bring something more up to date and concrete than what's here. Obviously, you've got to have something to go into the long-term plan, so there's an end date by which time we're into the next year of financials. So we're presumably this side of like May. So yeah, some advice on that.
I think we can commit to pulling something together. I think because we haven't landed a date of when that workshop will be, but I would have thought, yeah, April-ish would probably work.
Councillor Southworth, I mean, you're happy with 47 in the sense the workshop will be held, and then you want information to come back from that workshop to us here in the Water and Land Committee.
Sorry. I'm just wondering if we need a recommendation that says a report to come back to council at the most appropriate committee around April 2024. We can't be more specific than that, or whether this conversation and a note would be sufficient. I'm not sure. That's maybe for the chair to decide.
I mean, as the chair and deputy chair, we can sort that out and make sure it follows through. If you're happy with that, Councillor Southwood. What? Yeah. Councillor Paul. Oh no, Councillor Robinson. Yeah, no.
Just a question of clarity, really. It says in your report, number 13, there's 931 known fish screen facilities. Yet we've only monitored 220 of those. That's less than a quarter. Is that because of any particular reason, or is it budget, or just the capacity, please?
So since 2018, we've monitored 220, but it's mainly a staffing capacity with the right technical skills. That's the main limiting factor we have.
Councillor Paul.
Yeah, and I think that's at the crux of the matter, right? And we heard it from Paul as well about, you need the data to understand how to move forward. So, and so it does lead into that LTP discussion. So my question is, obviously, we've been working on the LTP. So is this something that you've already projected for in the stuff that we've been considering around that, or would this be additional once you have the workshop?
You might recall in the LTP that under the different scenario package, we had an uplift in our compliance function. So that's really where this falls. About resourcing, yeah.
Kia ora korua. Thanks, Mel. Judith, you may leave the table. Therefore, I'll put the motion, which is on page 24. Just note that we noted Councillor Southworth regarding next steps in 47, so that'll come up in a minute. Recommendations on 24, that the Water and Land Committee receives its report on proposed fish screen facility work program and notes that this work fits within the wider context of Environment Canterbury's compliance work under Environmental Regulation and Protection core services. Please have a mover. Councillor Southworth, seconder, Councillor Pauline. Any discussion? Councillor McCoy.
Yeah, thank you. Just really want to acknowledge how much of a thorny issue this is. And we heard this morning all around the fish screen issues, not only protecting obviously someone else, but the natives as well. I think just for me, point 31 there, which outlines some of the recommendations that come out of the working group there, particularly around what sort of an ongoing role might look like. But I think they've touched on a whole lot of things around the industry, regulation and scientific expertise to support Environment Canterbury. But on the other end, the irrigation companies or anybody, a consent applicant that has a fish screen or has the need to put a fish screen in for a direct take from surface water, they also equally don't have the information at the other end around what to do. So I think that we just need to acknowledge that this is not something that's going to be resolved quickly, and that's why it hasn't been resolved quickly. And there is a lot more information and science and a way of doing stuff to come yet. And I think I can see some benefits in a technical advisory group within Environment Canterbury, but this also becomes a national problem with more surface water takes. So I look forward to what comes out of the staff's recommendation and the working group that you're potentially setting up in the new year. And I'm happy to wait and make decisions further on.
Good, Councillor McCoy. Any other discussion? Councillor Paul.
Yeah, look, it's obvious, and it's pretty hard reading some of this, isn't it? And like Councillor Robinson, referred to 700 consent, fish screens we haven't looked at since 2018. There's a lot to do. So my hope is that what staff have put forward already is enough, and I think that's why Councillor Southworth's note is really important. That the until we can be sure that it is enough, you know, because from the risk angle and all that, because that seems to be there's a whole lot of work that needs to be done and we're just not getting to it. So we need to make a decision as a council about how much do we put in so that we do get to it. And so that does alleviate some of the concerns that we're hearing. And of course, that you can see in the data that we're getting back, 131 out of the 220 non-compliant. The previous information from 2017, 2018, 91% ineffective, 83% non-compliant. You know, they're massive numbers, although knowing that it's really technical. So yeah, I just, you know, look forward to the work that staff will do. The workshop's obviously really critical, but so is that coming back to us so that we can help understand and then make the decision about what the right level of resourcing is to deal with it. So thank you.
Yeah, kia ora, Councillor Paul, and that goes on to, I think, what Councillor Swiggs mentioned before about the work program and the LTP and other things about engagement. And we did have, you know, Paul come in today and talk about fish screens and also not only, and it's got brought up by Councillor Southworth as well, not only the introduced fishes, but also the native fish species as well, what that happens to them. And we also have, you know, Te Runanga Arowhenua, John Henry, the champion of that, and he always comes in and reminds us, and you know the figures do tell the story. But I'll just be saying, if you know, we've got the LTP coming up, that if anyone would like to do another submission to the LTP, we probably need to put funding towards this if we want to make sure that we can move in the right direction. But the motion's been put forward. It's moved by Southworth, Councillor Southworth, seconded by Councillor Pauling. Is that? Where? Oh, geez, man. Where are you? You're in bloody Siberia, man.
Just a comment on fish screens. Between 2007 and 2011, I was responsible for 4 fish screens, and they were all compliant. But when the requirement came around on native fish, they were questionable in terms of whether they were doing the job on those. So I think the question we should answer here is the fact that not that there aren't fish screens, there are fish screens, but to get them to the level where they are effective against native fish is pretty difficult, because that screen size is quite small, and those screens do block up really, really quickly when you're taking out of a creek or whatever. So it's not as easy as what we may think, but Mana Whenua's requirement to protect native fish about getting into those irrigation dicing machines is relevant, and I think that's a sticky point for us. So that's just a comment, yeah.
Councillor Mackenzie.
Yeah, thank you. And it's really to do with native fish. And Judith asked the question about the terms of reference for the tag group. But it seems to me there is some nuance required in our deliberation on what water takes and the nature of those takes that fish screens should apply to. Because in fact, if you look through the stockwater race system throughout the Canterbury Plains, for example, you'll find that there are a lot of native species which actually find that habitat a hell of a lot safer than living in the main rivers where predated on by trout and other beasties. So it may well be that I think we need to reflect on whether there's no question that irrigation takes need to have screens. I'm not pushing back on that. And anything else that might mince up the fish, of course. But if there are takes where, in fact, the water comes out of the river in an off take rather than through a pump, and then maybe it gets returned or goes into a habitat which is suitable for native fishery, we should perhaps consider not requiring fish screens on some of those types of takes.
Councillor Mackenzie, Councillor Swiggs.
I just wanted to explain a little bit about why I asked the question I asked before, because I was just, when I read the report initially, I was sort of going, well, you know, not really making a substantial decision, especially on a work program that's not fully developed at a time that we might be endorsing that before we've gone into making a decision for funding through the long-term plan or our annual plan program. So that was kind of where I was coming with it. I just, you know, the chicken before the egg kind of thing. But where I was going with that is that, you know, I think as we start to go down our path of, you know, sorting out the consenting backlog and unpicking some of that stuff, I think we really need to be focusing on that other side of that equation, which is the compliance and the monitoring side of our organisation. So from that point of view, I'm a big fan of, seeing these things, but it is a very highly operational matter. And once the program is put together, whatever that looks, I'd be quite keen to sort of have a decision come back to us rather than sort of going backwards and forwards and that kind of, with these things. So I'll support it, but I don't want my support to be a preamble to saying I'm endorsing a work program that is costed without actually looking at the wider budgets. So thanks.
Kia ora, councillor. Therefore, motion's there, moved and seconded. All those in favour, please say aye. Aye. Against? None. Moved. Kia ora. It's 10 minutes till lunch. We've got 8.4. Yeah, we might adjourn early. Come back at 10 to 1 for the 8.4 update on recreational water quality. Kia ora. Kia ora tātou. No mai hoki mai. Ki tēnei hui, tēnei ahei. Just to clarify, I did ask the chair if I could speak Māori 2 days ago, and he said yes. So kapai, haere tonu. Moving on. We're up to agenda item 8.4, update on recreational water quality. I have the Director of Science next to me, Dr. Tim Davey. I'll ask Dr. Elaine Moriarty at the table, and also Joe Taylor. Now, damn it! Now I've forgotten. What? Over to you.
I'll just very quickly introduce it and say that you'll recall at the last Water and Land Committee, there was discussion around the contact recreation and particularly the matters around Whakaropo and Akaroa Harbour. And today we are wanting to report back in and around things that have been done, which is a mixture of on-the-ground action and also engaging with the community. So Joe is from the comms and engagement team and has been involved in more of the engagement side, and Elaine is the surface water science manager and involved particularly in discussions with Christchurch City Council. You'll note that one of the authors of the paper is Tim Drennan from Christchurch City Council. Tim's contributed into the paper. Unfortunately, he can't be here today, but what Elaine's going to be presenting on is some of the stuff from the Christchurch City Council. So, kia ora. Elaine.
Kia ora koutou, and thank you very much. I'll take the paper as read, but I'll just highlight just a few slides of some of the work that has taken place. So the purpose of this presentation is to report back on the work, as Tim said, that is happening on the ground between the 3 agencies, and it builds upon previous presentations that we've given to you as a team over the last probably 9 months on this. So just a reminder, our summer bathing season is November to March. The sampling kicked off just about 2 or 3 weeks ago. And when we do our grades, our long-term grades, we look at 5 years worth of data, as well as a sanitary survey that's carried out on our site. And together that gives you your long-term grade. Now, the results of this, as well as the weekly monitoring, can be found on the website LAWA. Can I swim here? So we talk a lot about the work that we do as an interagency group, and I thought this diagram might be helpful in outlining our roles in that group. So that group comprises of Environment Canterbury, which is the blue, then the Territorial Authority, which in the case I'm discussing today would be Christchurch City Council, but maybe Timaru, Ashburton, etc. And then Timana Ora, Tifata Ora, which participate in the discussions as well. And we come together as an interagency group and make key decisions. As you can see, our role is right at the beginning in collecting the sample and getting the sample analysed, while we come together for communications. All health warnings, you will have heard me say before, come from health. They come from Te Whata Ora, not from Environment Canterbury. We then share their messaging. And work our way through where signage is put up, and then we have media press releases, and we get together at the start and the end of every bathing season and set out how we're going to work together as a group. So just a refresher on the grades for this present season, apologies. The ones that you'll see have changed to fair is Charteris Bay, has a decrease in grade. And then we have Cass Bay and Church Bay, who are also fair. Just a map there of Whakamutunga, Littleton Harbour, with our colour scheme of blue being a very good site, then green, yellow, and right down to red. So you'll see Corsair Bay, which we discuss a lot, is orange, which is in that poor state where swimming is not recommended. Looking over to Akaroa and Banks Peninsula, we have good quality water for swimming over in French Farm by the boat sheds, but unfortunately, Devotional and Tikau Bay, the quality of the water there has decreased to the extent where in Tikau Bay it is poor and no swimming is recommended at this location. And again, just a map, colour map with the grades on it. So the work on the ground, which we're focusing on this, at the moment, and Joe is able to speak to this if required, we have an ongoing work programme and campaign that we are engaging with the community, from A&P shows and the fair over in Orton Bradley, which we attended, and some councillors from City Council and Environment Canterbury were there, along with Te Whata Ora, to putting up health notices, sampling during the wet and dry, so extending our sampling this season, and collecting some samples for fecal source tracking where appropriate, where we wish to determine what is happening and where it's coming from. To focus on Christchurch City Council's work, their work programme is laid out in the paper. They have been sampling the waterways and the stormwater drains to try and identify any sewage leaks. And as you're aware from previously, they did locate one in Corsair Bay, which was found, tracked and rectified. They have also been undertaking additional sampling in collaboration with Environment Canterbury. They have been inspecting their own assets, such as the stormwater drains, the pump stations, roadside curbing, the toilet blocks in places. And they also are highlighting that there is a new wastewater treatment plant under development for Akaroa. And this will remove the current discharge of treated wastewater from Akaroa Harbour onto land. So that's just the summary of the work that's happening at the moment on the ground. Thank you.
Kia ora, Elaine. Nothing else? Is that it?
Yep.
Kia ora. Any questions or clarification? Councillor Southwood?
Yeah, just one. We were talking about getting additional sampling, working with the local community, and then doing some of the sampling. And I'm just wondering, if we've progressed that, is that happening, or do we not now feel we need to?
Through the chair, I approached Dan Abel and Leith Cooper on a number of occasions and offered this to them. They haven't come back to me yet. The offer is still on the table, but we are looking at additional or alternate citizen science that we will do during the summer with a different group. So we still intend to do it and would welcome their participation, but at the moment they have changed their focus onto a different location. So they haven't come back to us.
Yeah, sorry, just thinking as well, because you raised Abel name, and I know Dan Abel's concerns has been particularly around us potentially pushing people to a less safe swimming beaches. I'm just wondering, is there any update? I know there was work that's not directly us, but around sort of the communications and improving some of the information around the safety from a physical and currents point, currents etc. point of view. do we know any more about what's happening in that space to help inform people that they don't go somewhere that's actually more hazardous, just in a different way? Thanks.
To the chair, on the LAWA website, it does include some safety messages like that, but I think it would be overstepping our mark to go any further than what's on LAWA. The recommendation, I think, that's known by the public is always swim between the flags, so that if that's something they're interested in, that would be always somewhere we would promote, such as Sumner, Waimari Beach, Taylor's Mistake. They are all patrolled beaches and have safe water quality.
Yeah, kia ora, thank you so much for this report. It's really good to get another update so quickly from our last one, and I'm hoping that will, keep that going. Yeah, just noting in the report there about, you did note that one CCC pipe had been found and had been fixed in Corsia Bay. That's really good to know. But no other obvious source of contamination has been found yet. Although we're saying that it's most likely smaller sewer pipe leaks. Can you explain a little bit more about that? What is that, from septic tanks, or what are we talking about there? That's on point 18.
To the chair, so this again would be within CCC's area of expertise, but from my knowledge of it, when we do our sanitary survey, which is the team walk around each of these catchments in dry weather and wet weather, our feeling is if it was, a really big sewer pipe or a really obvious pipe that was a large volume discharging of wastewater, we would have found it by now from wet and dry weather observations, and we haven't. So that's leading us to believe that, as opposed to, one smoking gun, it's lots of smaller ones. So to your point about on-site wastewater, yes, it may be. And to that, we have done leaflet drops informing the community for Akaroa and Whakaropo. And we have also discussed that at all of our community events with the public and informed them as to what steps they could take, such as getting it serviced, where to go, simple things to look for, like, a really green spot on the lawn. So we've been working in that. The reality is, with a wastewater system like we have in Canterbury that is aged and gone through a number of earthquakes, there's bound to be cracks and breaks that aren't very obvious and that are under the surface and that may be leading to it. They are working to find leaks, but it's not an easy, just one broken pipe, unfortunately.
Yeah, so just clarifying, so a lot of these pipes may be pipes that are on people's properties that link into the reticulated system, so they will be private drains, private sewerage pipes. Yeah.
Through Chair, they could be any of them. They could be laterals coming from the property, or they could be further down once it gets into the TA's land. It could be either.
So just keen to know then, what is the CCC and I suppose our joint work program to continue to look at that? What does that look like? Have we got enough capacity in our system to, and as CCC, do we know what they're doing in this space to, obviously it's an issue, what are we going to do about it?
To the chair, within Environment Canterbury, within my team, I am fully resourced and able to respond where necessary. The team are incredibly willing to work weekends, evenings to go out and do this monitoring, so I'd like to thank them. I'm not in a place to discuss the capacity within CCC, so I prefer not to do that, but they have been very cooperative and helpful to us in any of the sampling that we needed their input on.
Yeah, I was just wondering whether, in fact, we should copy the way we deal with farmers and have mammalian exclusion from the waterways, household environmental plans, and significant and heavy-handed compliance monitoring to sort out the terrible behaviour of the people around Littleton, Akaroa, and Christchurch.
Are you off your high horse yet, or what? Sorry. Councillor Mackay.
I was going to say we note your views.
As I think we've discussed before, finding small individual breaks like that are a lot more difficult, and our approach is always education before we move down to the ease.
Thank you. I just want to go back to the question that Councillor Bolling was asking around the on-site wastewater systems. Are they all reticulated out there, right around the harbour?
They all have the option to be reticulated as far as Pura Bay. That's not to say that individuals may have not connected. I would be surprised what we're seeing is coming from an old septic tank, and that would be the only ones that I imagine are not reticulated, because the signal we're getting is quite fresh, and that's due to the chemicals. When we look at them, we can say it's a fresh event, and it's high enough concentration. When I did some back of the envelope calculations, and very crude calculations, it was enough for CCC and us to be confident that it's not coming from just septic tanks. So they're most likely contributing, but they're not the sole source of it. As far as Pura Bay, Pura is not reticulated.
Councillor DJ.
Yeah, in regards to Dan Abel with Fit and Able, I seem to remember from the Water Zone Management Committee meeting, he had expressed that a big issue for him was the cost that his group had incurred. Is that something that's a barrier for their input?
The option that I sent to them was that we would pay for the sample analysis, and that we would have an ECAN staff member help and facilitate it and direct the method of sample collection and analysis, so that the data would be of a similar quality that we could then use in our model, that it's useful, because there's nothing worse than empowering community to collect data that's then not used. So no, I don't believe so. No, I haven't.
Well, yep.
On a semi-related line, I know you and I had met up with one of the companies that provides automated testing. Has there been any movement or progress with them?
Through the chair, this is a company called Adroit, and Shirley Hayward and I spent a number of weeks looking at the information and meeting with them. My assessment from what's available, thank you, is that firstly, they look at E. coli, and for our marine beaches, it's enterococci. So at the very beginning, that's a real big issue. Their level of detection isn't sufficient for the safety of our beaches. And we, at the moment, are waiting to see if there's further development of them to make them suitable for beach use. But at the moment, unfortunately, it's not an option, but it's something we'll keep looking at.
Councillor Byrne, followed by Chair Scott.
Kia ora, thank you. And thanks for the report. Can you also pass on our thanks? I can't speak collectively, but I will go. To your staff as well for being so flexible in there. Thank you. Kia ora. Awesome. My question's kind of, do we have any capacity to do monitoring around water-based craft and vessel discharge?
That is not something we look at. There's a number of rules and regulations around it under the Harbour Master, and the distance, I can't remember, is it 10 nautical miles? There's a distance in the plan that says how far they need to be to discharge. I've also looked at those type of calculations and the output from them, and looked at what we're detecting in the beach, and I'm happy to rule them out currently.
Can I just supplementary to that? Because I'd be interested for things like, for example, if there was any spiking in and around the sailing event, for example, given there were masses of watercraft on the Whakaropo at that time. So, yeah, anyway, just a thought.
None that we detected. And also, it's, if you think about, and I don't boat, but those craft tend to be out further in the harbour than close in when, you know, it's a little cove, and that's where we're getting the you know, it's circling around a contaminant event there, as opposed to a large, you know, a large vessel out at sea where it's more open and hydrodynamics of it. That's why we tend to get really good quality at our beaches, which face out to the ocean, and less so than in our smaller enclosed harbours.
Kia ora, councillors. Elaine, just going back to the Littleton Harbour whakaraupo, the page you had, yeah, just on Motu Kauetiiti, Corsair Bay, and Pō, and then I think you talked about being fresh, and now I'm taking that was Corsair Bay. Yeah. So the recommendation would be not to swim there. Is that right?
The current recommendation for Corsair, based on the data we have, is it's good to swim during dry weather, but if there has been rainfall in the previous 48, no? Oh, sorry, no, apologies. Oh, Corsair, I was thinking of Cass, apologies, thank you. Corsair is don't swim there regardless of the weather. Cass Bay is the one that is impacted by weather. So yeah, apologies.
Thank you for that. Any other points of clarification?
Oh, sorry, I go to Peter if you want. So, Elaine, thank you so much. And I was just checking on Lara again, just to understand again what the community can see when looking at the data. So I can see here that if you look up Corsair Bay, you can get the weekly results that are pretty recent. So the last one was the 22nd of November, which is pretty recent. There'll be another one coming up soon, I'm sure. And when you look at those results, I mean, the community can use them to help them make decisions on any given, well, each week. So those results show as being, like, it's only 10 at the moment, 10 out of per 100 mils, and it's showing up as green, which is suitable. You know, if you look at the guide. So, I mean, but that's still helpful for the community, but that's how it works, right? A weekly data download directly to Lawa. That's as frequent as it is. There's no other.
The chair, sampling occurs on a weekly basis, so that's how, you know, how frequently the data is typically updated. Sorry,
I've got it open right here. So I was looking at it, and if you look at the very top of it, shows as red, which is to do with the long-term grade. That's the first thing. You can delve down and look at, because we are still monitoring it, so you can see the weekly, and that's the idea, that it is a risk-based approach, and it's saying we don't recommend it, but there are information there. There is information there that is a bit more recent.
I've forgotten about, you've got the tracking graph that shows the sort of long chain of points of actions that we do, and right early on we've got taking the sample and then transporting to the lab within 24 hours. So I know one of the big discussions has been like that length of time it takes to get a result back. So you're essentially only ever knowing the water was safe after you've swum in it. And I'm just wondering, like, to what extent do we go? Because 24 hours to get something from like Corsair Bay into the lab that's just over the hill seems like an awfully long time. So I'm, you know, I mean, we're not taking that long, are we?
through the chair, in short, no. The guidelines say to transport your sample within 24 hours. So if the team go and collect it on a Monday morning out on the beach, they collect that along with about 10 or 15 other samples. You know, they work their way through, they're stored in a chili bin, and then they're transported to Hill Lab to get there before 4 o'clock on that day. Hill Lab will probably start to process them at 8 o'clock the following morning. So they're within 24 hours. And then, so that's your Tuesday, they're processing them, incubate them. Wednesday, the lab staff read them, and we may be informed Wednesday evening if there's an exceedance, or Thursday. So it's just the process here.
Kia ora, kōrua, Elaine, Joe, thank you. You may leave the table. Kia ora. First, put the motion on the screen. Oh, look at that. Oh, Charles. Moved by Councillor Pauling, seconded by Councillor Burns. The recommendations are on the screen. Any discussion at the mover?
Yes, thank you. Look, I just really want to acknowledge the staff again, as others have done a really good job on this, and like I said, bringing it back to us. A lot of interest. I've got a personal interest in this because I take, kids and other members of our Waka Club out in that area all the time. So I'm always really conscious about what are we doing. That's why it's sort of good to understand that LAWA information and how we can make a decision every Sunday, as it is, whether we expose our kids to that or not. So, just that's where it's really pertinent to me, as well as the whānau at Rakaia and others that are doing this stuff all the time as well. So my thing is, I asked the question about the CCC work programs, partly because I know we can't comment on their work programs. They are with their work programs, but I make the point that we're the consent authority for the sewage discharge that comes from the CCC system. And so I think we do have a right to ask them some more questions on this and to work with them collaboratively to just see what their work program is about going forward, about trying to find the solutions here. So that's sort of my plea, is that, yes, I know it's not our complete business, but we are that consent authority, and it is in our interest to understand what their work program is to rectify these things. So I'm just really keen, and that's why I wanted to move the motion, because especially the second part, I really think it's important that we keep working collaboratively with the council and Whatu Order. But I think we should ask for more information, just to have they got the capacity to deal with this going forward. If we think there is broken pipes in those communities, how can we help them? I'm assuming it would be an education program, some sort of work with landowners to say, hey, you might have broken pipes on your property. Here's a program that CCC and ECAN and Whatu Order have that can help you put you in touch with the right drain layers, whatever it is. See what I mean? I'll get going towards that in a positive light, so that we try to get some movement on it. And it's not about people mismanaging their properties. Most of them won't even know. Most of them won't know that there's an issue underneath their land. But how can we help them, A, find out, and B, try and fix it? So that's what I'm really keen to see happen. And like I said, because it's our role as the consent authority, regulator in this case, to have an interest. And of course, at some point in the future, those consents will come up again. So it's all important in how it goes forward. So yeah, just really support what we're doing, and thanks for the work.
Councillor Pauling, Councillor Burns, would you like to reserve your right, or Councillor Scott and Councillor Swiggs?
So just associated with this, last week I gave a congratulatory speech to a combined effort between ourselves, Mana Ora, the Canterbury District Health Board, Mana Ora, and CCC, and that was about health across all policies. Now there's some stuff here that seems to be repeating itself, and it's mismatching ourselves. And one of the things that I've said to them is that we need a stronger governance presence in that forum. In my conversations with Mihi and others, there's also that urban waterway stuff, and there's that health stuff around that, and it's the stuff about when we do have incidents, who puts the signs up. So I think there's some of this stuff, Chair, that we could actually formulate ourselves a little posse on this, and maybe speak to that group, get that group combined. And I know the lady, and I can't remember her name, from Mana Ora, but she's really keen, Anna Stevenson. So Anna's really keen to do that, have a conversation, and that seems to me to be the right sort of thing to do that with. And I think city people, yourself, maybe I don't know, if you're all interested, then we should do that with them and see if we can work some stuff out.
Scott's Councillor Swiggs.
Yeah, just to Just wanted to sort of say something on regards to what Craig was saying around the laterals on private properties. There was a massive program, obviously, in the city that happened, and it wasn't really transferred over to the hills at that point in time, and I don't know where it went, but it might be worthwhile for us to kind of consider talking to EQC as well, as they do have long-term statutory obligations in those spaces. So didn't think about it before, but I'm just sort of putting it out there as an idea for people to have a talk to. They've got an immense amount of data, and again, they have a forever statutory obligation in that space.
Councillor Swiggs, Councillor Southworth.
Yeah, just say thanks. Staff have been really engaged on this, and including with City Council as well, and particularly also through the Zone Committee. And I think the community members have been really, really active, and gone to quite some number of events and so on. So it's actually been really positive working with what's actually fundamentally a really unfortunate and negative situation. It's I think we've done really well to get to where we have. And I guess proof will be in the pudding how things work out over the summer period, when obviously that will come to the fore, the frustration around limited number of beaches that are recommended for swimming in. And so we'll just keep going, and I'll perhaps touch base with Councillor Tyrone Fields, who's the rep on the Zone Committee, and just make sure that we are all really joined up and keep the pressure up in terms of the actions that need to happen to ultimately solve the problem at the end of the pipe. So thank you.
Order. The recommendations there, moved by Councillor Pauline, seconded by Councillor Burns. All those in favour, please say aye. Aye, against? None, carried. Kia ora. Thank you for that. Moving on. 8.5, portfolio work program, water and land, page 42. Nicole Linz and also Cameron Smith. To the table, please. Any comments? No. Over to you two. Kia ora kōrua.
I'd like to recommend that you receive the water and land portfolio work program for Q1. So that's to the 30th of September. The attachment at the back of the paper, which I'll take the paper as being read, but the attachment 8.51 is the water and land section of the organisation performance report that was provided on the 1st of November to the Audit Finance Risk Committee. Within that, all of the levels of service were on track bar one, which was at risk. Would like to provide a post-quarter update on that level of service, being level of service 2.1b. This is on our Mātauranga Māori program, post Q1. So we have finished revising that and have revised and made some changes to our monitoring program. And we're now confident that we'll be on track to achieve that by the end of the year. So in Q2's reporting, you'll see that reflected as a green on track comment. Within the other notable achievement and issues part of the paper, some items you might not have seen yet, is the CWMS Water Zone Committees have now completed and published their annual progress reports. You can find all of those on our website. At this stage, you've got to go into each zone's page, but we are seeing if it's achievable without too much time and money to actually collate those. So they're located in one link, but that's not there yet. Item 12 is some detail. The CWMS, sorry, I need my glasses on to look at the paper and don't need them to look at yourself, sorry. In August, the Canterbury Mayoral Forum agreed to an evaluation and review of the CWMS structures by 2025. The review will be initiated early in 2024 and will consider how to support the community leadership
and engagement needed to drive improved freshwater and environment outcomes at zone or catchment level. The paper also just notes the success of the Te Rauputuia Awananga held in September with Whakatupu Runanga representatives along with Runanga environmental entities and ECAN staff. And this is noted here just due to the key aspects of the development to the regional policy statement that were discussed and explored in that wānanga. So I know a lot of you would have been there, so I just won't go into that detail. So any
and kia ora koutou, and if I just may add a further update, particularly with regards to our work on improving outcomes in Otu Wharikai, and there's an update on page 50 of your report on this. I know it's been a lot of interest to this committee, so I'll provide just an update on work over a couple of months that hasn't been captured within that text there. We are now actively considering a review of the two consents up in Otu Wharikai, along with processing the further 2 consent applications. We've also, the work around the catchment, the integrated catchment plan is progressing as part, and that's being developed through the external Otu Wharikai working group. And they had their first wānanga in November, earlier this month. That focused on establishing a knowledge base and also identifying the high-level objectives for that integrated catchment plan. And it was well represented. We had a number of key agencies there, including most of the landowners. And so that work progresses. There has been a slight delay. It was to be produced by December this year. It is now being produced by March next year, which will be in time for the next mana hui. Thank you.
Kia ora, any questions of clarification? Councillor Pauling. Kia ora, just on the Mātauranga monitoring one. So just trying to be really clear about where we're at, and that's great that there's been sort of a revised, outlook on that, and that hopefully can be achieved. So it says there we have a draft monitoring framework. So we have a draft framework in place, or proposed. Sorry.
So we commissioned and naming it Gail Tipper to do some work around a framework. That we have got that. So we've got that. What we are revising is, I guess our initial intent was to take that framework and sort of take it round and say, how does this look? We're just going back a little bit and saying, doing a little bit, instead of being a bit top down, doing a bit more bottom up of saying, what is it you really want, and does this framework fit within that? So the way that the level of service was written was a bit more top down. What we're just revising is coming. So we're going to be talking with Whakatupu Runanga around what is it that really want, and in the meantime, getting some monitoring underway that hopefully will fit within the framework, and we'll just see how that goes. So.
Thank you. I think that's really, really great. It's great to know where we're at, sort of more specifically. I'm wondering if, obviously that's not published or anything, but is there a way to get a further briefing or update on just those key aspects and then that work that is proposed for the coming year?
Through you, Chair. Look, we actually had it down to do it at this meeting, and then it just we were still working through a few issues, so we fully intend to bring back a briefing on that.
Yeah, Councillor Willing, that'll be in the March week. Who's next? Swigs. Yeah.
Can I just get an update on the Three Waters reform and implementation, given that there's some executive orders being stop work notices being put on that stuff? Does that have many implications for our staffing numbers, resources? It might be too early to sort of say, but just give us an update about that.
And through you, Chair. Yes, so I quite often think about the Three Waters reform as having 2 key components to it.
One is increasing and improving the standards that apply to wastewater, drinking water, and stormwater. And the other is the creation of these new water entities. On those water entities, there's been a lot of uncertainty about those for some time now. And so there hasn't been a lot of very little resource from our staff going towards those. However, we're not anticipating much, if any, change associated with wastewater, drinking water, stormwater standards. So that's where the majority of our focus is. It's working with our TAs and through a lot of our compliance work, but also working with Taumata Arawai to actually understand what some of these new standards might look like.
Just can I just because I know we were having to pile a whole lot of information to send to councils or to somewhere about the council's performance and all of that sort of stuff. Where is that at? Because I mean, I understand that there was quite a lot of time and effort being put into those processes. So that's kind of what I was kind of worried about more.
And through you, Chair, yes, there has been a significant amount of work that has gone into the data compilation to provide back to largely central government so they actually understood. A lot of that was based on them having a better understanding of the wastewater treatment plants, etc., and the consenting status and compliance status of those. We're not putting any work into that at the moment. And into as far as the data provision back to central government as part of the Water Services Recreation.
Councillor Swiggs, Councillor Southworth.
Yeah, just a little question with the Whakaropo under partnership programs. It mentions a mapping project, and I just want, what are we mapping? Is it coast? Is it the land? Is it biodiversity? What are we mapping?
It's through Chair. I can answer that. I checked up. This is a sediment source mapping on the land, and it's with University of Canterbury. So.
Councillor, Chair Scott, do you okay, Councillor Burns.
I'll follow up outside the committee. Thanks. Sorry.
No more questions of clarification. Thank you, Nicole Cam. You may leave the table. Kia ora kōrua. The motion will put up on the screen. A recommendation on page 42. Receives the work program report for Q1 23-24 for the land and water portfolio. Mover. Councillor Southworth, seconder. Chair Scott. Kia ora kōrua. Any discussion? Councillor Burns. Scott.
Yeah, just a comment on the CWMS process from the Mayoral, coming out of the Mayoral Forum. We've had quite interesting debates with mayors for some time at the Mayoral Forum regarding zone committees and keep reminding them that they're a joint committee, they're joint set up, owned by the Mayoral Forum. It's sort of increasing in intensity around the effectiveness and those sorts of things, and we keep answering the questions with the same, the same answers, wash, rinse, and repeat, really. But the caution that I would try to offer to mayors is that because people are going, look, we've got catchment committees and they're set up and they're doing better work than the zone committees can do, and that's because I think the purpose of the zone committees probably been lost a wee bit. But my caution would be that those catchment committees are pretty much funded by MPI, and is that funding going to last? And is that a process that this government will pick up and allow that to happen again? So if that funding does dry up, then where do we go from there? Because if that's the link into the community, and somewhere along the line you need some statutory guidance on what's going on and what's possible. And so I think we just need to be, my caution is we need to be careful on that. So I think we're bringing that review forward a bit to ensure that we can get some of that information back to them, because they're pushy on it.
Thanks for the clarification there, Chair Scott. Councillor Burns. No, nothing. No one else. No one else. No. Right. Therefore, no more discussion. Councillor McKenzie. No. Moving on. Recommendations there moved by Councillor Southworth, seconded by Chair Scott. All those in favour, please say aye. Aye. Against? Kyle. Carried. Kia ora. 8.3. Now we have the auspicious occasion of someone flying all the way from Western Australia, from Perth, just to be here today for this debrief. Kia ora, Dr. Fiona. Thank you. Over to you regarding the current pesticide monitoring programs. Yeah, Antarctica. Antarctica? Do you lead climate change? No.
It's an important educational trip with an opportunity to influence a large number of people about climate change. Oh, kia ora koutou. Thanks very much for the opportunity to present this paper to you. It's come about following a discussion on the feasibility of pesticide monitoring at the last Water and Land Committee meeting. So Matt Riddle, who is our senior scientist in the land resources team, has done an excellent job working right across the science group to understand the current and past pesticide monitoring programs that we've had. So the details are provided there in the paper. It provides really an outline of some past snapshot studies, as well as sharing information about the longer term monitoring programs we have, particularly in relation to pesticides in groundwater and our contributions to national pesticide monitoring programs. So I'll take the paper as read, but just wanted to reiterate the point that we believe that our current approach, which is really based on monitoring those pesticide residues in groundwater, taking that as the receiving environment rather than splitting it up into different places where applications might be more direct, is appropriate based on the previous results that we've had. And it's in line with results from national surveys. So our scientists are certainly maintaining a watch and brief, looking at concentration changes, as well as understanding the impacts of pesticides on the receiving environment. They're well connected through a range of different national groups, and we're certainly happy to bring back any further developments as they come to this meeting. Kia ora.
Kia ora, Fiona. Question clarification, Chair Scott.
I'm pretty interested in paragraph 34, because I know what simazine is and where it's used. I know what versatile or archer is and where it's used. But I looked up DET and it said it was a hallucinogenic. So I'm just wondering if farmers are where are they applying that? So what is the chemical DET, derivative DET? That's a serious question.
Yeah, sure. I am not a pesticide expert and I don't know what DET is specifically, but we can certainly find out and come back to you there.
Any other questions for clarification? Councillor Southwood?
Yeah, well, just, I mean, DET, I'm pretty sure is the one that's now no longer used, but it's got a very, very long half-life. Yeah, but it's also DET, I think. Anyway, so you'll check on that, but that's. So, but just, sorry, just that's, I think that's a legacy one, but anyway. But I'm interested in terms of, so from 2018 and the data that we've had, we've decided we're only going to monitor every 10 years. Which seems like an enormous amount of time to me. And I just wonder, like, should we review that decision more frequently than every 10 years? And the reason why 10 years seems like such a long time, and we had that presentation last committee meeting about soils, and that we do our soil, go around and check soil health or soil quality more frequently than 10 years. And the reason being, and the reason why it was suggested that we should continue doing that, is to gather that baseline. You can start to see if there are trends before they become a problem, etc. And a bit like what was mentioned somewhere earlier on today, there was mention of, goals can shift. And we know, for example, the European Union is constantly looking at what's an acceptable health level of these various huge range of different chemicals being used for herbicides, pesticides, and so on. And so, how do we respond if the goalposts change and we've only been looking every 10 years? What if it turns out that actually what we think is okay today in another couple of years' time, we have to conclude isn't, and we haven't been looking, and it's shifted quite a bit in the last 4 or 5 years since we did something in 2018. To me, that just, I don't feel like that's a very good base, or it's just, to me, it doesn't feel frequent enough. And I'm also curious about the cost, because I've found out recently about just a broad suite of pesticides, and it was around the $150, not 600 and something. So whether that's a higher detection level, that was a cheap price, but not going to the very, very detailed level of or whether it was a narrower suite of like more commonly found. So I wonder if there's some cost savings could be done on a more frequent program, and then you'd go to that very detailed level, or a really wide range of potential pollutants every 10 years, if that's what's considered. But I just feel like I would like more confidence in the scientific basis, given the changing goalposts in this area. Yeah, I would like some more comfort that actually once in every 10 years is sufficient. And what do you think, Fiona?
Thank you, Vicky. In terms of the 10-year decision, I might let Tim speak to that in just a moment. I guess the piece of visibility that we are keeping closely in touch with is the national level survey, which is done every 4 years. So we would have 2 cycles of those before we got to our 10-year threshold. That enables us to keep an eye on things at a national level. We do contribute to those surveys, but certainly take your point about things can change, and how do we assure ourselves that we're getting the right information at the right time. In terms of the cost savings for analyses, that's obviously something that could be explored, but the figures that are presented here are current prices for a full suite of analyses by a standard commercial provider here in Christchurch. So whether or not there are opportunities to look at things at a less sensitive level, in many respects, I think if you're going to do it properly, rather than leave out bits of the puzzle. But I'll pass over to Tim in terms of any extra context around that decision following the 2018 survey.
Through you, Chair, I was just going to say the same thing, that the 10-year is not meant to be 10 years with no information in between. It is informed by the national survey that's going on as well, and any other information that we would have. So it's not to say that if something did change, we would say, oh, sorry, we can't do anything for 3 years. We would bring that forward if there was something, but it is very much informed by the other information, is the way that we're approaching it.
Kia ora, Councillor Mackenzie.
Just to say to the council that DET is a degrading form of laser. It's actually a forestry product. It's also widely used to release trees.
Kia ora, Dr. Mackenzie. Thank you for that. Councillor Robinson.
Yeah, I would still like to see sort of an analysis of having soils included in the pesticide monitoring and herbicide monitoring. The reason, there's a few other councils considering it at the moment, from what I have talked to. And also with regards to 37 across the country, the pesticides detected in 17 wells, and that's only 9.2% of the samples, a well sample. But when we compare the 2022 to 2018, there's quite a different amount of wells surveyed, and only 117 a year ago, compared to 272 in 2018. So it's not really comparing apples with apples, as far as I'm concerned. And the ESR sampling rate is every 4 years. So it's just too much. There's not enough frequency in the testing regime. And I I really believe that we could get a more reasonable price for testing soils with other packages that we get tested at the same time. Whether or not that's with, like the suite you get tested at ESR or the likes or Hills Labs, whatever you use. It's cheaper when you add it to other suites of tests. I've looked at that as well. So I would like to see soils added to the mix.
Yeah, it's not really a question, but I'll just provide a comment in the sense that for us in terms of rolling out a monitoring program, monitoring pesticides in soils gives us results that can be really difficult to interpret. It's basically a snapshot in time. So if you were to go to a site, there may have been pesticides applied a week ago, 2 months ago, 2 years ago, and it's very difficult for us to understand what that means in terms of impacts on the receiving environment. So that is the rationale for us to focus on the receiving environment. That's why we're mainly targeting groundwater, because if things are moving through the soils and into the groundwater, that's where it starts to become more of a widespread problem. In terms of the analytical costs, we have long-standing relationships with lab providers and committed contracts and so on in terms of rates. So I am confident that we are being priced appropriately, but we can continue to ask questions to check on that cost effectiveness.
Councillor Robbins, follow up with Coach Pye.
I was going to say, I think the cost shouldn't be a hindrance to actually having a holistic view of your receiving environment. I think the soils shows one indicator because it is grabbing hold of these. I mean, it binds to soil, and it's good to see the life of it in the soil as well, not just the receiving water environment. So yeah, I would like to see that, please.
Councillor Southworth, is this the same issue?
Well, it's right. Sorry, I'd forgotten the DET because I did look at it. The turbophile lazine is something that's relatively frequently used, I believe, including in her sort of horticultural practices and the like. And it is, I was talking about some of the concerns that are being sort of looked at, more investigation going on in European Union. That particular herbicide, I think it is, that is also that breakdown product, the DET, that Councillor Mackenzie flagged. From the concern there is about it accumulating in lakes in particular. And so I'm just wondering whether, perhaps we should be looking at what are our senses, because again, we've put this into the context of drinking water standards, but actually where it is in our natural habitats and environments. So, should we be looking at, for example, Te Wahora, for example, being, some of these end of the specific places where we know we might pick up if there's a building, an accumulation of some of these things that we know we've got a sensitive receptor that could be, part of a program, just checking in that we're not seeing something getting worse with and the catches of unawares. And it can be those breakdown products that they actually have a longer half-life than the original parent. And I think there's several breakdown products of that turbophile lazine. So it might be that it's the DET, the one to watch. There might be other parts. But yeah, I just think maybe we should look more smartly. Perhaps it's a handful of places we at least get a sense of what these things might be accumulating in our natural environment, where we can be watching what other parts of the world doing to help us, so we don't have to do all of it, but that we can at least pick up on the signals and know that we've got a reasonable handle on where might this be a growing problem, where might it be a problem for our natural environment.
Couple point taken. Kia ora. Thank you for that, Councillor McKay.
Yeah, look, thanks for that paper. I'm pretty comfortable with where we're at as an organisation. I think there's certainly some leadership to be shown by the EPA and nationally, and I think that should be perhaps a signal for us perhaps to look at close things. I think the thing that concerns me is the sense that we're willy-nilly throwing around herbicides, fungicides and insecticides across our Canterbury landscape, and it would be really interesting, and it's not something I expect our science team to have, but from my experience, the amount of chemicals that are being used on our land are actually reducing year on year on year. So that gives me a degree of comfort for the long-term monitoring that we have. So yeah, I'm more than happy with what we currently see.
Councillor Mackay, thank you for that. Councillor Burns.
Kia ora, this is kind of an odd question, but this is aimed at you, Mr. Director. Like we used to have testing labs within Environment Canterbury, and I think that went about a decade ago. Has there ever been any thought or about whether or not some of the testing components that we do require may be better in-house?
Through you, Chair. Look, I mean, the short answer is no, it hasn't, because the service that we're getting from third-party providers we consider to be very good. At the time that the laboratory went, which was just after the earthquakes, we weren't doing it was doing standard chemical analysis. It certainly wasn't doing anything like we're talking about here, and that requires extremely expensive equipment, and it would be very unlikely to, well, I'm 99.9% sure that it would not be cost effective for us to do it in-house.
Thank you for that, and that's terrific. Just a thought at the time. And I've also got another one based on what Councillor Mackay just said, that obviously in your experience that chemical use is decreasing across Canterbury. Is there any way of us finding out, in fact, the volumes of chemical that are put on in agriculture across Canterbury, so that we can, in fact, have a factual, this is how much is purchased or moved through the industry on each annual basis?
Couple on that note, no more clarification. Yep.
I do have a question just based on the conversation. I can't quite work it out in the report. Is this just looking at rural areas, or is it looking at all waterways in all areas?
So the sampling that has been done across the region. I'm not sure on the proportion of urban versus rural waterways sampled, but the sites that have been selected at various stages in the past were intended to be representative.
I'm none the wiser on that, because I'm just, I'm hearing an interesting conversation just had, but I just wouldn't mind knowing that data and finding that out if that is possible, because it would be quite interesting just to sort of look at that.
But if there's no points, questions, or clarification, well, thank you, Fiona, for coming all the way from Perth just to brief us. So enjoy your rest when time you get home. Therefore, we'll put the motion on there, 8.3. It's on page 30. It's there. Can we have the mover? Chair Scott, seconder Joe Davies, Councillor Davies. Kia ora, kia ora. Oh, why? He's in a minute. I got it. Any discussion? Councillor Robinson.
I've just been.
I'd like to say one is that this organisation has 110 science people that are involved in water quality and assessing things. And so I know there are lots of opinions on these things, but we need to ask the right advice. So we need to be saying to the staff, are you happy with this? Are you happy with the testing? I think that's the question we should be answering, rather than adding in the things that we should be testing on. And just the amount of product that's being used. So I don't know if you're up with this, but every horticultural or arable entity now, the requirement, if you're supplying a product to anyone, is to have a spray diary. So you need to actually, when you're supplying your crop to them, is to supply a list of the things that you have applied to that crop. So that information, I'm sure that if you're really desperate for it, you could get it. But they actually, because a lot of this product goes offshore, need to be compliant to European standards also. So that's the check there in terms of that. The tariffs that are offered in those countries of import are around those things about residues on products. So we need to be aware of that. I mean, the things that we probably should be more cautious about is the amount of residue on stuff coming into this country, and the possible herbicide residue on those, because I'm not too sure if we have the same rigour around that.
Councillor McKay.
Just adding further to that, it's the same applies in the dairy industry. Any chemicals they have to be recorded, and they are audited through an auditing process.
Kia ora koroa, thank you for that. Councillor Robinson.
Yeah, I understand some of those tests, and it's good to see. However, if you go back through some of the ResearchGate information on some of those herbicides, the initial testing has been done in soils as well, and they're actually quite alarming as well. And I think we do need to consider adding soils to the mix to get a holistic view of what's going on. And horticulture, we need to also look at some of the land we actually spray and that we've reconsented ourselves for 30 years coming as an environmental organisation. We need to actually hold ourselves to account as well. Do you know what I'm saying? I would like to see soils added to this, and otherwise I won't be supporting it. Thank you.
Kia ora. I will be desperate to know this, because otherwise I'll be waking in the middle hours of the morning, desperately sort of trying to multiply and add and divide and whatever. But I would be happy outside of this meeting if someone could give me some lead on how I could, in fact, come up with some sort of reasonably confident sort of amount of chemical used in Canterbury. That would be great. Thank you very much. And by the way, I'm glad that you identified 110 of the water quality people who we are very fortunate to have. Kia ora.
Kia ora, Councillor Burns. So I take that Chair Scott will personally look at that. Any other? Councillor McKenzie.
Thought you were going to say no again, yeah.
I'm a fair and reasonable chair.
Of course. How could I possibly question that? Look, if I I suspect nobody wants to hear this, but there is no point in having a quantum of chemical used, agricultural, forestry, or horticultural chemical used across Canterbury as a number, unless you know how it's applied, the land area it's applied to, and what it's applied for, and what crops it's applied to. Otherwise, it's a meaningless number. It tells you nothing. And it's the same with soil sampling for agricultural chemical residues. Unless you actually have such a comprehensive soil testing regime in place, which I think our head scientist pointed out, the information you'll get will be meaningless. And the cost of putting such a comprehensive soil testing plan, and when actually the evidence suggests we don't have a problem in the first place, would be a complete waste of ratepayers' money. And if I can just add, I think something like a third of the Canterbury Plains is now in dairy farms, something like that. Certainly in Ashburton district it is. The other third is, well, perhaps a bit over about the other 2/3 is in arable or horticultural crops. The third that's in dairy farming just doesn't get very rare, maybe once every 10 years has chemical applied to it. So the incidence of use of chemicals has gone down with the land use change. Now, if you want us to go back and move out of pastoral farming to other land uses, then the amount of herbicide and fungicide and pesticide used will go up. The other thing I would say is that we had a testing regime on wheat going into the flour mills, and they identified that there was a high incidence of insecticide on the wheat. When they analysed it, it was actually all on Australian wheat, because they regularly treat all their wheat with actelic dust, which is to kill off mites, and very little of the New Zealand crop gets treated. And so the mills then said, oh, we want to ban the use of actelic dust or monitor the use of actelic dust. And the New Zealand wheat industry said, fine by us, but you'd have to stop importing grain from overseas, predominantly Australia. So Peter's right. Yeah, you've got to understand what you're asking for and the reasons for it.
Kia ora, Councillor McKenzie. Councillor Joe Davies, any comments from you as a seconder before we agree to go to the motion? Okay.
Just to sort of reiterate, for me, I completely acknowledge. I think that everybody, and including it, everybody is aware, more and more increasingly aware of the concerns around these types of products. There's been many that have been banned over the last several decades and more. And so, I don't doubt that the amount of application and so on is decreasing. At the same time, there's really, new products coming on the market, and you don't know what that unintended consequences of some of those are for some time to come. And obviously, there's checks and balances in place to try and avoid having things come back out that will come through that are going to cause problems in the future. But there just seems to be a constant, issues and concentrations building and so on, and I just feel like I'd like to know that we're on it, and from the point of view of the ecology, not just, it concerns me when I see things always connected back to drinking water standards, when an awful lot of our water never comes through anybody's drinking water tap. It goes into our natural environment, and it's the tiny critters that form the basis of our ecological web that are often the most vulnerable, and we need to be across that. So I would really like to think that the science team would look closely at some of those places where we might see accumulation, or be able to monitor and track and see other things coming through, and just know that we're across that and not just finding something pop up. And I accept that there's national survey every 4 years. It'd be really interesting to know where are those focused, and are they again in groundwater wells and looking at more of a drinking water aspect, or are they looking specifically at sort of ecological value in those places that might be at the end of the pipe where we might start seeing low levels picking up? So I just like a little bit more confidence, and I don't know how, do I need to propose an amendment on the recommendations to have that done, or?
I think Chair Scott has said that we 110 science staff, and that he personally will look into some of this mahi along with the Water and Land Committee. This paper was brought to here, and we'll kind of always look at how we feed on from this. But otherwise the motion's been put. Unless there's any quickly further for discussion, we're gonna move these motions. Right, all those in favour say aye. All those against? I want that noted. Yeah, Councillor Robinson's against. Kia ora koutou. On that note, that's the end of the hui. 3 minutes over. So sorry, whānau. Next meeting is the 13th of March 2024. Therefore, from the chair, Merry Christmas and Happy New Year. And see you on the 24th or the 13th of March. And closing Karakia, Councillor Burns.
Whakatau mai te wairua, whakawatia mai te hininaro, whakariti mai te tinana, ki ngā hau I whā, ti hei Māori ora.